The case of the prosecution, which is based on circumstantial evidence, would not be established. So the appeal is allowed. JCRL is allowed. Both the appellants are acquitted. They will be discharged from their bail bond.
I agree. It's a lot of stuff. You are upon get number? Huh? Dako.
23, Mr. Mishra is there. 9.
One get number? Asan. Paper.
Item number 28. And 28. I'm praying for Passover for today, my lord.
पढ़न तो आमे सांग होई कि नहीं देखियो
फाइलटा छडा पढिछि म फाइलटा छाडी माने आस्ति नै
पेपर बुकटा धरै देले
मैं प्लीज
just a minute. कितना नंबर आइटम एटा
28.
What is your good name?
Agni Shikha Rai, my.
You have power in this case?
No, my lord. On behalf of Mr.
Says no.
What is the how many years you have practiced?
1.5.
Only.
No.
Oh, will not take it.
So 10 years minimum is needed. Where is Patel?
Mr.
Where is your senior? It's not a regular appeal, it's a jail criminal appeal. And it has been assigned to Mr. Patel. He should not have also the other associates of Mr. Patel should not have signed the Wakalatnama. Even if they have signed, it's all right. But because the case has been entrusted to Mr. Patel to argue. So no, legal aid committee देखिए
Privately
private but JCR
normal JCR and the committee there, and there was a privately. Huh? Privately engaged? No. Then non Rao ki
court engaged bar is engaged
legal committee. Okay, Korean. Mr. Patel has to come. Kindly inform him.
Mine.
ଆଉ କିଏ ଅଛନ୍ତି ଡାକନ୍ତୁ ଗୋଟେ ମ୍ୟାଟର ଆରମ୍ଭ ହଉ ଆପଣ ସକାଳୁ ଆସିକିନି ମିଷ୍ଟର ତ୍ରିପାଠୀ ଆପଣ କନଫାର୍ମ କରିକିନି ଜଣେ ଦି ଜଣଙ୍କୁ ଡକେଇକିନି ଆପଣ ରେଡି କରିବେ ନା କଣ ଏମାନେ ସମସ୍ତେ ରେଗୁଲାର ପ୍ରାକ୍ଟିସନର କଣ ଜେଲ କ୍ରିମିନାଲ ଆପିଲ ଅଫ ଦି ଇୟର And next page re ए जो जेल क्रिमिनल अच्छी आपनकर गवर्नमेंट एडवोकेट ही गलेनी जे कटकिया तो
रगड़ also
रगड़
ना
हाँ
रगड़ तो हमें ଏବେ ଦେଇନୁ ୟା ଭିତରେ କି
ଅଛି ଏଇଟା ଆଙ୍କର ଯୋଉ ଥିଲା ବର୍ତ୍ତମାନ
ସେଇଟା ତ ଦେଇ ପାରିବେନି
सेटा देई
ସେଇଟା ଏଲଏନ ପଟେଲ ନିଜେ କରିବେ
एलन पटेल निजे करिवे ताऊ इंटरेस्ट हेची दीपाली महापात्रंकर गोटे अछि आइटम नंबर 40 जीएन मिश्र मीना कुमारी दास these are all regular Surjyakant Dwivedi these are all regular practice
ବିବେଦିକ ହଉଛି 46 ଥିଲା ମୁଁ ବସିଥିଲା ଏଠି
अरे
Item 25.
In this appeal, my lord, both the appellant, two brothers, convicted under section 302 for under section 449, 302, and 34 of the Indian Penal Code for committing the murder of deceased Ravi Pradhan.
how many persons were facing trial
2 persons, my lord.
so one is Purushottam Pradhan and the other is Karna Pradhan right
2 brothers, my lord.
and both of them were found guilty
My lord.
they were okay charge was under section 302 by 34
My lord.
Okay.
Charge sheeted under section 449 also. This is the
No, not charge sheeted. We are, yes, both are charge. Okay. So, one is appellant.
the
Just a minute. Purushottam A1. Or no. Charges 449, 30534. And what happened? What is the judgment? What is the conviction?
conviction, my lord.
Acha,
Life imprisonment.
no. On both the charges, the accused persons were found guilty, right?
My lord.
And sentences arrive for life to pay fine of rupees 5,000. In default, to further undergo RI for 1 year, 302. Then RI for 3 years, pay fine of rupees 3,000 each. To undergo 6 months, 449. All right. So please come to the FI. Let us know the first.
Page 25, your lordship.
Yes.
25.
27.
27 is the written.
Paper book, my lord.
Right. Please.
May I read, my lord? Ambhesri Vikram Pradhan.
Ket number saki?
Vikram Pradhan is the PW2.
PW2.
my lord.
Okay.
Peter Panchanan Pradhan. Panchanan Pradhan is the brother of the deceased. The Vikram Pradhan, the informant.
What is the name of the deceased?
Brother of the deceased.
Oh, deceased or nada?
Ravi Pradhan.
Ravi Pradhan.
both are sons of Panchanan Pradhan.
हाँ,
Yes. Panchanan Pradhan is PW1.
पंचानन प्रधान इज PW1.
Man.
ओके,
Father of the deceased.
हाँ,
বয়স 30 ବର୍ଷ, ଗ୍ରାମ ଗଣିଗୁମ୍ଫା, ଗେରେକରି, ଥାନା ଦଶପଲ୍ଲା, ଜିଲ୍ଲା ନୟାଗଡ଼। ଆଜି 3/8/2004 ମଙ୍ଗଳବାର ଉପରବେଳା ପ୍ରାୟ 3 ଘଣ୍ଟା ସମୟରେ ମୋର ସାନ ଭାଇ ରବି ପ୍ରଧାନ ଘରେ ଶୋଇଥିବା ବେଳେ ମୋର ଦାଦା ପୁଅ ଭାଇ କର୍ଣ୍ଣ ପ୍ରଧାନ ଓ ପୁରସ୍ତ ପ୍ରଧାନ ବାରିଶି ଓ ଟାଙ୍ଗିଆ ଧରି ତାର ଶୋଇବା
these are the two appellants, right?
ବାରିଶି ଓ ଟାଙ୍ଗିଆ ଧରି ତାର ଶୋଇବା ଘରେ ପଶି ତାର ବେକ ଓ ଛାତି ପେଟ ଉପରକୁ ଆଣି ହତ୍ୟା କରିଛନ୍ତି। ହତ୍ୟାକାରୀ ଗାଁ ଛାଡି ପଳାଇଛନ୍ତି। ଘଟଣାସ୍ଥଳରେ ଗୋଟିଏ ଟାଙ୍ଗିଆ ପଡିଛି ଓ ମୋର ବାପା ଏ ବିଷୟ ହନୁମନ୍ତ ଶ୍ରୀ ପ୍ରସନ୍ନ ବେହେରାଙ୍କୁ ଆପଣଙ୍କୁ ଖବର ଦେବାକୁ ପଠାଇଥିଲା। ଆଜି ସକାଳେ
ମାନେ କି ଏକ୍ସାମିନ ହେଇଛନ୍ତି ସେ ଯୋଉ ହନୁମନ୍ତ ପ୍ରସନ୍ନ ବେହେରା? ହେଇନାହାନ୍ତି।
ପ୍ରସନ୍ନ ବେହେରା not examined.
And ହନୁମନ୍ତ କଣ?
ହନୁମନ୍ତ equal to ଗ୍ରାମ ରଖି my lord. They are called ହନୁମନ୍ତ.
ଓକେ, ଓକେ।
ପ୍ରସାଦ ବେହେରାଙ୍କୁ ଆପଣଙ୍କୁ ଖବର ଦେବାକୁ ପଠାଇଥିଲା। ଆଜି ସକାଳେ ଖଳିଦୁମ ବିଲରେ ଧାନ ରୋଇବାକୁ ନେଇ ମୋ ଭାଇ ସହିତ ପାଟିତୁଣ୍ଡ ହୋଇଥିଲା। ସେହି ରାଗରେ ମୋର ଭାଇକୁ ଶୋଇଥିବା ଅବସ୍ଥାରେ ସେମାନେ ମୋ ଭାଇକୁ ହାଣି ମାରି ଦେଇଛନ୍ତି।
Okay. Is it a case based on direct evidence or circumstantial evidence?
Circumstantial evidence.
Circumstantial evidence.
Though the PW1 and PW2 they have claimed as eyewitnesses, but they are actually they are not eyewitness to the occurrence.
Whether they have been believed by the learned trial court or disbelieved?
No, disbelieved.
Disbelieved.
Yes, ma'am.
Both of them.
Both of them.
Okay.
PW1 is the father of the deceased.
No, let us come one by one. You said that the case was during trial it was projected as a case of direct evidence, and the two witnesses 1 and 2 they deposed as to the eyewitnesses to the occurrence.
Yes,
but the learned trial court has disbelieved both the witnesses.
Their evidence.
Okay.
And relied upon the evidence of their confessional statement before PW 13 and 14.
Just a minute, we are taking note of it. So direct evidence of PW1 and PW2 disbelieved. Okay. Then what are the circumstances on relying on which this conviction has...
PW they have confessed confessed before PW 13 and 14.
Okay. Extrajudicial confession.
Normal, not extrajudicial confessor. They have surrendered before the
they are police officers.
Yeah, both are police constables.
PW 13 and PW 14 are two police officers.
So that belongs to horrible PS, my lord.
Okay, all right. So before them, it is stated that confessional statement has been made.
Soon after the occurrence, they have fled away from the spot, and in the evening they have surrendered. They have stated the PW 13 and 14 stated that they have surrendered and stated that they have committed the...
Okay, this is one aspect. That means extrajudicial confession is one aspect. What are the other circumstances?
No other independent witnesses are there.
No. What are the other circumstances?
Yes, ma'am. So
leading to discovery, last scene, this, that. So what are the
in this case, my lord, IO is PW 15.
ଆମେ ଆପଣଙ୍କୁ ପଚାରୁଛୁ କଣ, ଆମେ କହୁଛୁ ଯେ ଆପଣ କହିଲେ ଡାଇରେକ୍ଟ ଏଭିଡେନ୍ସ ଡିସବିଲିଭ ହେଇଗଲା, ତ କୋଉ ସର୍କମଷ୍ଟାନ୍ସିଆଲ ଏଭିଡେନ୍ସ ରେ ଯଦି କନଭିକ୍ସନ ହେଇଛି ସେ ସର୍କମଷ୍ଟାନ୍ସ ଗୁଡାକ କଣ? ଆପଣ କହିଲେ ଗୋଟେ ଅଛି ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ବିଫୋର PW 13 and 14 who are the two police officers. ୟାକୁ ଛାଡିକିନି ଆଉ କିଛି ଅଛି ନା ଏତିକି? Okay, you do one thing, you read one of the accused statement of any of these so that it can be known that what are the... You please come to page number 32.
Relevant portion of... Yes,
no, yes, that would be easier to find out what are the circumstances.
Yes,
come to page 32.
32.
That is the accused statement of the appellant number 1. Yes.
It transfers from the evidence of PW 1. Pancharam Pradhan, that you are sons of his elder brother and you are living separately. What do you say?
Leave it. Just question Pacharjan.
Yes. 2. Question number 2. The replied that yes. It transfers from the evidence of said PW1, PW5, and 6 that on hearing south at his Sara, PW1 came along with his captain PW6 and Chabbi PW5 and found you and the co-workers near the door of the house and saying, "Ao kiye asibo, aso hani debu." And by that time you are holding a tangia.
So these two witnesses are also material witnesses, PW5 and
Yes,
6.
yes.
So what happened to the trial court? What finding has been given on these two witnesses?
They have not stated before the IO, my lord.
Okay, we'll see that. So PW5, PW6. That is
stated in their one.
Well, we'll see. Just that is why it is very easy to know from the accused statement
Yes.
what are the circumstances. Seeing both the accused with weapon stained with blood. Okay, come to the next one. Next question.
Question number 3.
Yeah.
The question number 2 replies no, my lord.
Okay, ठीक है
Yes. Question number 3. It further transfers from the evidence of PW 1, 2, 4, 5, 6, 7, and 15 that they found the deceased Robbie lying on a rope cot after being assaulted on his belly, chest, and neck.
Okay, there were injuries. Next question. Come to the next question.
They said, I cannot.
Okay, come to the next question.
Yes. Question number 4. It further transfers from the evidence of PW2 that on the same night, on arrival of PW15 police officer, he lodged a written report via Exhibit 1 before him.
So PW2 is the informant.
The brother of the deceased.
All right. Yes. Next. Next question.
Yes. That question replied, I do not know.
Yes,
PW5. It transfers from the evidence of PW15 that
the registration. Leave that question. Yes. Come to the next one.
Question number 6. It transfers from the evidence of PW.
Photographs taken. Leave it. 15. Leave that. That is photograph. Yes.
Second photograph.
Then next question number 7.
Question number 7.
Held inquest at the.
It transfers from the evidence of PW 1, 2, 3, 4, 8, and 15. They
are the witnesses to the inquest. Okay.
They are witness to inquest.
Okay. Next question.
Next question. Question number 8. It transfers from the evidence of PW 1, 8, and 15 that police seized bloodstained tangia MO1 sample at bloodstain from the
spot. It was seized.
One tangia was lying at the spot, and another was holding by PW apple and number 1.
Yes. Next question.
Question number 9. It transfers from the evidence of PW 7 and 15 that
body of the was sent for postmortem.
The dead body of the deceased.
Leave that. Come to the next one.
Yes, sir. PW question number 10. It transfers from the evidence of PW 7, 10, and 15 that the wearing apparel
seized. Okay. Next.
Yes. Question number 11.
It is a doctor conducted postmortem.
PW 9, the doctor.
Again, you leave the question number 12 also. The nature of injury has been described. 12, 13, 14, 15, and 16. These are all related to the PM doctor. All right. Then also 17 injuries are possible. 18 MO1 is the weapon of offense which was produced before him. Okay. Next. 19 collected nail clippings. Leave that. Then transfer from the evidence of so and so that you along with the co-accused went to. This one is relevant. So question number 20 ta padhantu.
Question number 20. It transfers from the evidence of PW 12, 13 14 and 14 that on 4/8/2004, you along with co-affiliates went to the Harbunga PS along with Itangia and told.
Okay,
to
and
the
that
board.
so you only pointed out two witnesses, but that there are three witnesses on this point.
12, 13,
ଆପଣ
14
13 14 କହିଥିଲେ ନା କିନ୍ତୁ 12 13 14 ଏବଂ ସେଇଟା ହଉଛି ଟାଙ୍ଗିଆ ପ୍ରଡ୍ୟୁସ କରିକିନି କନଫେସନ କରିଛନ୍ତି ବୋଲି ଏଭିଡେନ୍ସ ସେ ତିନି ଜଣଙ୍କର ରହୁଛି. Okay, then
To PW12 is also IO in this case.
okay, we'll see that.
Uh-huh.
Just we want to know that what are the okay then.
Proceed number 21. It transfers from the evidence of the said PWs that you were both,
Okay, stained with
are
blood,
wearing lungi and gamucha, which were stained with blood.
blood stained wearing apparel,
Proceed number
appellants. Okay.
22.
Hmm.
It transfers from the evidence of PW14.
CSD entry ଛାଡ଼ନ୍ତୁ ତାପରେ next
Question number 23. It further transfers from the evidence that said witnesses that PW15 that the Tangia handle and iron portion separately was seized by the seizure list exhibit 13.
so Tangia seized
Exhibit 13 the
from A1, okay, on being produced by appellant number 1. All right, next.
question number 24. It also reveals from the evidence of PW14 that he has identified the Tangia by the MO3.
जोड़ा produce कला
Yes, madam.
appellant. Okay, next question.
Question number 25. It transfers from the evidence of PW12 and 15 that on this same night, OIC Daspala, PS PW15 arrived at Harbunga PS, and you and the co-official
Handed over to
him by said PW12. What do you say? They said no.
Okay.
Question number 26. It transfers from the evidence of PW15 that
He arrested wearing apparel seized.
both the both and
Okay,
seized your
wearing apparels, that is bloodstain wearing apparel seized. Okay.
seized to hide exhibit 5 in presence of witnesses. What do you say? They said no. The question number 27. It transfers from the evidence of the said witnesses that on 12/8/2004 exhibits were dispatched to
Okay, leave that. Next. So that is C report.
28. Question number 28. It transfers from the evidence of PW15 that sees the stationary entry.
Stationary.
For the
given Jimana.
period.
Next question. C report.
Question number 29. It further transfers from the evidence of evidence that he received the chemical examination report.
Okay, so human blood thila apanଙ୍କର axe jota produce
Human
करले
blood available moderate condition in moderate condition being belongs to O group, my lord, O plus.
Then next question.
Question number 30. It transfers from the evidence of PW15 that he has identified the seized Tangia by MO1, seized Lungi MO2, seized handle of Tangia MO4.
PW15 की है?
PW15 is the IO of Daspala piece.
Okay, one of the investigating officers.
Investigating officer.
Okay. Next question.
Question number 31. It also reveals from the evidence of PW4 that he has identified the seized Tangia marked MO1 and the seized Lungi of the deceased marked as MO2.
Next.
Question number 32.
15
it transfers from the evidence of PW15 that on completion of the investigation, he finds prima facie material submitted charge sheet. In this case, against you both.
So let us come one by one. Let us see that PW51 कौन से कोई चीज है? Come to PW1.
PW1.
Yes.
Father of this.
पढ़ो. is the father of the deceased.
Page 41, my lord. Pancharan Pradhan.
Hmm.
I have got two sons, namely Vikram and Ravi.
Ravi is the deceased.
Ravi is the deceased, Vikram is elder, and Ravi is the
And Bikram has been examined.
Vikram, my lord.
Bikram examination.
Yes,
Yes.
PW2, your
Yes,
lord.
sir,
Oh,
PW.
PW, that is the informant.
Right.
Right. Okay.
My wife is dead since last 5 years. My elder son has got married. Damayanti is the wife of Vikram. Both have kissed Karna and Purushottam, and my nephews being sons of my elder brother. My elder brother Budhiya is dead. My brother's family and my family are living separately. About 2 years back, one day at about 2 to 3 p.m., my son Robbie was killed by both the accused persons, being assaulted by means of tangia while he had slept in the room. By that time, I was at my Salo Ghara, which
Solaghara.
which is 100 yards away from my house, where Robbie was sleeping. Nobody was present at that time. My son Vikram had gone to the house. Damayanti, my daughter-in-law, had gone to work in the field. I heard about I heard shout while at Salo and came to the spot along with one Captain
Capitan Malika and
they are PW 5 and 6.
Okay, good.
They are PW 5 and 6.
and PW6.
I found both the accused persons near the door of my house, and they were saying to cause assault. If anybody come, saying that ଆଉ କିଏ ଆସୁଛ ଆସ ଆଣିଦେବୁ. One of the accused Purushottam was holding a tangia which was stained with blood. Out of fear, we could not detain them, and they went away. When we entered into the room, we found my son lying dead on the cot, on being assaulted on his belly, chest, and neck. The neck was half cut. There was a rope cut. One tangia was lying there, having blood stain, and the blood stains where they are throughout the room. Then I called other villagers. Then I asked one
Person of
village, Hanumat. Namely Hanumat,
ଗାଁଟା ନା ହଉଛି ହନୁମାନ
Name of person.
village
Place.
Hanumat.
I asked one person of village ହନୁମାନ ମାନେ ଗାଁ ନା ହଉଛି ହନୁମାନ ହଁ ଠିକ ଅଛି
Who informed police over telephone. I also intimated the fact to the grammar office who were present at the spot. My son Vikram came after grazing cattle in the evening. Subsequently, police arrived at the spot in the same night. On the date of incident, my deceased son had gone to the land of accused persons to cultivate on bhagya basis, but he was restrained by the accused persons. Then my son came away. Since I restrained, after his arrival in my house, I went to Sado. On the same night, police examined the dead body, and on the next day morning, the dead body was sent for postmortem examination. By the time of occurrence, my son was wearing a lungi, and the tangia was seized by police.
Okay, so from the chief examination, as it appears, even though he has not seen the actual assault, But he
After-
came to the spot immediately on hearing
After-
shout,
My lord.
and both the accused persons were present, and one of them was armed with a tangia,
Thank you.
that is appellant number 1, and they said that कौन से words कहले, आउ किए आसुचो आसो हानि देबु, and then they entered into the house and found the deceased lying on a cot with injuries on the so and so. Okay, so read the cross examination. All right.
Yes, man. Para 5. I am not witnessing the state tangia in the court. I found both the accused persons standing in front of my house on Dando from my sala. I heard the accused person saying "Ki aso" from my sala. I found Purushottam was wearing a lungi by that time, but I cannot say what Korno was wearing then. We reached
When we reached
when
this spot,
this spot, both the accused persons fled away.
Yes.
At a distance of 50 yards, I saw accused personified, accused persons fled away. By the time of my arrival, my brother and nephew, other than accused persons, were not present.
We are not present.
Not present. My son Robbie was lying dead in my house. Captain and Sabbi, they are PW 5 and 6. Went away from the door after witnessing the dead body. The room in which Robbie was lying may be 14 into 14 feet into 14 feet inside, approximately. The door is on one side of the room. Robbie was lying on the cot in the opposite direction of the door, in the middle of the room. The head of the deceased was to the inner side of the room, and legs were towards door side. By the time I witnessed this dead body, when it was
on steel.
Was on steel. There was bleeding. There was bleeding, but I could not try to put the cloth on the wound from my house. I directly went to Angada, Gramaraki, and also informed the villagers of Kerala. By that time, it was 2 to 3 p.m. Then I went to village Hanuman. Yes, sir. Village Hanuman, and to Ramachatya. I requested one Prasanna to intimate the fact to police station over telephone regarding the occurrence. Prasanna belongs to village Hanumantia, and he is son of one Balaram Behera. He has intimated to the police station that the accused persons have committed the crime. Almost all the villagers were present at the spot when I returned. I cannot say the exact time when police reached my village.
Yes.
The Tangia was lying near the cot on the floor of the room. The cot was stained with blood. No rope was detached from the cot. The throat was half cut. When I saw the dead body, no one was present at the spot when I went to inform the villagers and the Brahmaraki. It is a fact that there is another room of mine, which is a kitchen room intervened by the village Dando in between my house. It is a fact that I have partitioned my portion of land among my sons and myself. Again says that the land has not been partitioned among my sons and myself. It is not a fact that I am forcibly cultivating the share of
Pandav.
Pandav and my mother against the interest of accused persons. It is not a fact that
ଓ ଏଇ କଣ୍ଟ୍ରାଡିକ୍ସନ୍ସ ଗୁଡାକ ଯୋଗୁ ଡିସବିଲିଭ କଲେ ଏଗୁଡା ସବୁ କିଛି କହି ନଥିଲା ଫାର୍ଷ୍ଟ ଟାଇମ ବୋଧେ କହିଛି ସେଇଥିପାଇଁ ପ୍ଲିଜ ରିଡ ଦି କଣ୍ଟ୍ରାଡିକ୍ସନ୍ସ
it is not a fact that I have not stated before the IO that Purushottam accused was armed with a tangia and that at the time of occurrence nobody was present
and that
and that
I
I saw both the accused persons near my door. It is not a fact that I have not stated stated to IO and accused persons
told
ye asibo aso
Anidebu.
it is not a fact that I have stated to IO that my deceased son was lying on a rope cot and that one tangia was lying near the
ethi was
cot.
the statement there. This has been proved by through the investigating officer because he says that it's not a fact. That means it is to be proved through the investigating officer. So what who is the IO?
IO is IO.
Okay, you come to
PW50.
page number 82. That portion has been proved. Please come to page 82. 82 paragraph number 6.
Cross-examination.
82 paragraph number 6.
6, my lord.
Read it out.
I have examined PW1.
Yes.
He has not stated before me that at the time of occurrence nobody was present at the spot. He has also not stated before me that he saw the accused persons near the door stated that he saw the accused persons in the courtyard Dwara. He has not stated before me the name of Captain Malik and Sabim Naik to have accompanied with him to the spot. He has not stated before me that
He restrained.
This is while he was cultivating the land. He had also not stated before me that after arrival of his son.
But this is something different which has been
Not been
He went to
no. These questions were not to the
witness.
Acha. Okay. This. Please come to the further cross-examination. That is in the next page. Those things were put only. Come to the page number 45 of PW1. But please read it out. Page 45.
45. I am not witnessing the said
PW1 page 45.
45. Yes. Further cross-examination?
Right.
On the record. It is not a fact that I have not stated before the IO that I went to the spot along with Captain Malik and
this is being proved. Eta se kahini. Okay, next.
It is a fact that I have not stated before the IO that out of fear we could not detain the accused persons. It is not a fact.
This he admits. Okay. It is a fact.
It is not a fact that I have not stated before the IO that I restrained my son. But it is a fact that
while he was cultivating the land.
While he was cultivating the land, I have stated to the IO that after his arrival in my house, I went to Sara.
So, yaku chhadi diyantu. Ei jo jinsota se chief re kahila je mu shunili पार्टी शुणिली
ଆଇସ
पार्टी शुणिकी आसिली से आरो कहा सांगेरे आछिचंदी ताऊ छाड़ दियंतु से दीटा कहिनी अच्छा आसिला परे जहा देखिला सी कहूची जे दी जण अक्यूज्ड प्रेजेंट थिले one of the accused that means the appellant number 1 was armed with a
ଟାଙ୍ଗିଆ
टांगिया right एवं से एई कथाटी कहिला कहिला परे देन तापरे से माने एंट्री कले घर भीतर को जाई देखिले जे डिसीज्ड रो एई टाइप रो इंजुरी अछि एवं से पड़िछि जो ए जो पैराग्राफ 7 ने आपण जो कन्फ्रंट कले एगुडा को आपण कन्फ्रंट करचंती इट्स ऑल राइट बट दैट हैज नॉट बीन प्रूव्ड थ्रू द आईओ so the reason is perhaps that this witness has stated and it should not have been confronted to this witness so that is the reason why it was not put to the IO verify he jaithibo setebulu dekhila bulu ei jo आपण जो प्रथम क्वेश्चन टा पचारिचंती लेट अस से पैराग्राफ 7 रो जे इट्स नॉट ए फैक्ट दैट आई हैव नॉट स्टेटेड बिफोर द आईओ दैट पुरुषोत्तम माने एक्वेलेंट नंबर 1 वाज आर्म्ड विथ ए टांगिया this has not been proved to the IO जे
He had not
ଏ
stated.
କ୍ୱେଶ୍ଚିନ୍ ଟା ପଚାରିନାହାନ୍ତି
सेता माने एक एटा
This
किछि
stands.
पचारि एटा किछि नाही यार नेक्स्ट at the time of occurrence nobody was present and I saw both the accused persons near the door
In place of
हाँ.
door, it is courtyard.
it is courtyard
मान
next is ए जोटा language टा समान जो कहिचन सेते बळे utterance अछि
ଆସିବ
हाँ की आसुचो आसो हाणी देबु ए विषय रे there is also no contradiction and it has not been proved आपण पचार दिजन जे आपण कहिनांती से कोइला म कहिची but it has not been proved तो एई विटनेस को आपण कोन पई तळ माने ट्रायल को डिसबिलीव कले टोटली डिसबिलीव ना पार्टली बिलीव करछन को
Partly.
पैराग्राफ रे
Para 7 of the judgment.
अच्छा अच्छा पैराग्राफ 7 तो आपण जेमति कहले मु टोटल डिस्कार्ड कला बडा लागिला एडमिटेडली एट दी पैराग्राफ 7 ने where the evidence of PW1 has been discussed
para 7 my lord of the
Okay.
judgment
please read it out let us see
admittedly at the time of occurrence nobody was present in the house of the informant and while the deceased had slept in the cot he was assaulted soon after the occurrence on hearing shout PW1 father of the deceased along with captain
Kapitan Malik and
Kapit-
Chabi Malik.
Captain Malik, PW6, and Sabi Malik, so PW5, reached at the spot. PW1 was in his Saradhara at 10 years away. On his arrival, he could see both the accused persons near the
Bari of his house.
bari of his house, and accused Purushottam was holding a tangia stained with blood. Out of fear, he could not detain them, and they went away. From the evidence, it revealed that when he entered into the room, found his son lying on a cot, on being assaulted on his belly, chest, and neck. The neck was half cut, and one tangia was lying at the spot, having blood stain, and there was blood stains throughout the room. Then he asked a person to inform police over telephone and intimated the facts to Gramarokhi, PW 5 and 6. Both have admitted in their evidence to have remained present at the Saladhara at the relevant time. They went to the spot soon after departure of PW1. PW1 found the dead body lying on the cot with injuries having profuse bleeding. It is revealed from the evidence of PW5 that throat of the deceased was cut and he found both the accused persons going away from the spot. PW6 has stated that he along with PW5 went to the spot and found the dead body of the deceased lying on a cot, and a Tangia was lying there inside the room. From
The reason is this, Parag. The PW1 says that I went to the spot along with PW5 and 6. And I saw the accused persons, they are holding tangia, this, that, all these things, and they were uttering like this. But the two accompanying witnesses, that is PW5 and PW6, they have stated that we went with PW1, but only saw the dead body lying there and with injuries, and tangia was there. So the part which has been deposed to by PW1, that to have seen the presence of both the accused persons holding one tangia and saying these things, that is not corroborated by PW5 and 6, as it appears from the impugned judgment. Okay, read it out.
It
From the evidence of
from the evidence of PW1, 5 and 6, it is clearly established that soon after the occurrence, they reached the spot and found the deceased lying on a cot, and also the accused persons leaving the spot. From the evidence of PW1, it is clearly established that
It is not disbelieved.
by that time, accused Purushotam was holding a tangia stained with blood. After getting information, the elder brother of the deceased PW2, the elder brother of the deceased PW2 reached the spot. After being informed by his wife, he went to the spot and found PW3 and 4 present at the spot, and his brother was lying dead.
ଆପଣ ଯୋଉ କହିଲେ disbelieve ହେଇଛି,
Court
କଣ
has not,
disbelieve ହେଲା?
court has not disbelieved.
Not disbelieve. ଆପଣ ପ୍ରଥମରୁ ଆମକୁ କହିଲେନି ଯେ 1 and 2 are the eyewitnesses to the occurrence. They are actually not eyewitnesses to the occurrence. They reached at the spot immediately. One at least we have gone through.
It's well, they have not seen the actual assault.
Right.
Soon after
No, you simultaneously you said that
Yes, ma'am.
they have been disbelieved by the London trial court. But as we find that in fact the court has relied upon the evidence of PW1, and the finding is that it is clearly established that by that time when they found this spot deceased lying this, the accused Purushottam, means appellant number 1, was holding a tangia stained with blood. So that is there. Okay. So now the next witness is PW2.
Well,
Okay, come to that. Let us see.
PW2. He is also my lord post occurrence with
Just read it out.
Yes, ma'am. Informant mistake. PW2, namely Vikram Pradhan. Para 46. I am the informant in this case. PW1 is my father. This is Robbie, is my younger brother. I know the accused person standing in the dock. They are my brothers, having sons of the elder brother of my father. On 3/8/2004, Robbie died due to assault of by the accused persons by means of tangia. My mother is dead since last 4 years. On the date of occurrence in the morning, my younger brother, the deceased, went to cultivate the land of Jamuna
Pradhan and Purushottam Pradhan. Purushottam Pradhan is appellant number 1. Yes.
Since they have requested to cultivate the same on bhaga basis, there was a dispute in the family of accused persons. On hearing the fact, I went to Robbie and restrained him not to cultivate the land of Purushottam. Then he cultivated our land, and after returning to house, I want to graze the cattle. Then my father went to Sada. My wife went to work in my land near our Sadaghara along with one Susila. My wife intimated
यार wife examine ହେଇଛି PW2 ର wife ଅବିକା ଖୋଜୁଛନ୍ତି
PW2.
No, not, she has not been.
Not
Not
right.
examined.
All right. Read it out, yes.
My wife intimated me about the occurrence, and then I came back to my house at about 4 p.m. and found ward member Bobby Naik, Sarpanch, Aruna Jani, and other villagers present near our house. I also found my brother Robbie was lying dead on a cot, sustaining cut injuries on his chest and throat.
So he appears to be a post-occurrence witness who came to the spot on being informed by his wife and who has not been examined. And when he came to the spot, he found his brother, that the deceased was lying dead on a cot. There were number of injuries, cot injuries, and one tangia was lying there near the cot. So then he says that I lost the written report. So obviously the evidence of the PW1 is more relevant than this witness, because PW1, the part which he has stated about your presence of both the appellant at the spot holding one tangia, the other tangia is there lying and then uttering these words, then leaving the spot giving threat. This is there. So what further evidence he has given? This PW2, he had lost the report, then he is a witness to the inquest, and Tangia was seized. Okay. Anything you have brought out in the cross-examination?
This is the said tangia, para 5 minutes.
Uh-huh.
This is the said tangia in which the accused persons assaulted my brother and was seized by police. Marked as M1. This is the lungi which was owned by my brother at the time of incident and seized by the police, marked as MO2. Cross-examination. I lodged the written report at about 9:30 p.m. on the same day, same night.
Same night. ঘটনাটা খরাবেলে হয়েছে
2 to 3 p.m.
2 to 3 p.m. right.
So he reached the spot at the 4 p.m.
Right.
Thereafter, at night.
Okay, then police was intimated, police came, and he lost the. It's not that he had gone to the police station.
No.
Okay.
Police was
somebody intimated and they came,
PW1.
and then this FIR was lost.
I was examined by the police. My brother was lying on a tap cot. One chadar was put on the said cot. The chadar was stained with blood. On the next day morning at about 7 a.m., police held inquest over the dead body. I have not gone through the inquest report, and the same was read over and explained to me. Barisi, Tangia, and Kuradi are separate weapons. Nobody other than police has written anything on the inquest report.
Okay, come to the next witness. Let us see, because this PW3 is the inquest. Or
witness to inquest, man.
Okay, witness to the inquest. Then PW4.
PW4 under the Sarpanch. Aruna Jani, the Sarpanch of the village. I am Sarpanch of Chadhayapalli, GP. I belong to village Keravali under that GP. I know the informant and the accused persons who belongs to my village. I know the deceased. On 3/8/2004, I was in my village. On that day, I got information from villagers that accused persons have caused the death of the deceased Robbie. I went to the spot and found that deceased Robbie was lying dead on a cot in his house. I found cut injuries on the throat and chest towards belly, and one tangia was lying near the cot inside the room, having blood stain. There were blood stains throughout the room. On the request of Vikram, PW2, I scribed the FIR.
Okay, he is the scribe of the FIR.
Scriber of the FIR, PW2.
Yes.
This is my endorsement with signature on the body of the FIR marked Exhibit 1/2. In my presence, police had held inquest on the next day, and a report was prepared. After going through the same, I put my signature and endorsement marked as Exhibit 2/3. In my presence, police also seized the blood-stained tangia.
That was lying at the spot, and then sample earth, blood-stained earth.
Sample earth and blood-stained earth
Yeah.
from the spot and prepared seizure list. And I have signed on the same seizure list.
Okay.
This is the said seizure list and Exhibit 3. This is my signature thereon, marked as Exhibit 3/1. One Dinabandhu Jani was present by that time. I learned about the occurrence from Panchanan, father of the deceased. Deceased were wearing a lungi by that time. This is the said tangia
Okay.
seized by the in my presence.
All right. So he is one not only the scribe of the FIR but also
seizure of
the seizure inquest report preparation witness, then the witness to the seizure of blood-stained earth. Okay. Now you come to next witness, PW5. This, according to PW1, he accompanied PW5 and PW6 to the spot after hearing that shout. So come to PW5.
PW5 is 29. So page 52. I know the accused persons standing in the dock who belong to my village. PW1 also belongs to my village. He has got a sorrow. I know the deceased Robbie and the informant. About 2 years, 1 month back, Robbie died. 2 years, 1 month back, Robbie died. On the date of occurrence, I had gone to Sara of PW1. Captain Naik was also present there. At about 2 p.m., the occurrence took place. Panchanan went to the house and saw the son.
Panchanan ki? Oh, jo acha, PW1.
PW1.
Okay, yes.
Father of the deceased. Panchanan went to his house and saw his son Robbie lying dead. Then myself and Captain went to the house of Panchanan. Found the deceased lying dead after being assaulted. Seeing him, we went away out of here. We saw his throat was cut near a door. Near the door was
near the door we witnessed the deceased.
I also found both the accused persons going
Karna and Purushottam going away.
From the backside when Panchanan shouted, Purushottam and Karna are two brothers.
No, you see, as it appears, they reached a little late than PW1.
5, 6. They followed her.
PW1, as it appears, PW1 reached at the spot fast.
Thereafter,
of course, the evidence of
PW6 has clarified again.
Yes.
PW1, however, stated that he went along with
me.
he ସେଇଟା ସେ
ମୋ ସାଙ୍ଗରେ ଗଲେ ବୋଲି ସେ କହୁଛି
PW6 ବି କହୁଛି
ମାନେ କହୁଛନ୍ତି ଆମେ ତା ଶାଳ ପାଖରେ ଥିଲୁ କିନ୍ତୁ ପଛରେ ଗଲୁ।
ଆମେ ପଛରେ ଗଲୁ
ସେ ଆଗେ ଡୁଙ୍ଗି ମାନେ ଦେଖିଲା ସେ।
ଦେଖିଲା ଦେଖିଲା ପରେ PW ହଁ
ତାପରେ ଆମେ ଦେଖିଲୁ।
ହଁ
ଆଜ୍ଞା।
so this PW5 says that we went a little late, that means ତା ପରେ ଆମେ ଗଲୁ। what about PW6?
PW6
ହଁ ସେଇ portion ଟା କଣ ସେ କହୁଛି actually?
Captain 9 Captain page 54.
ହଁ
Panchanan has got a shala and I am in the habit of going to that shala of at Keravari, which is 2 kilometers from my village. Kantipadar. He is not the villager. He used to go.
Okay, you just come to the main part.
I know both the accused persons who belongs to Keravali. I know the deceased who is dead since 2 years. On the date of occurrence, about 2 years back, on a day, I had gone to Sala of Panchanan and PW5 Chabi was also present there. Near the house of Panchanan, there was
a halla.
Hanidele boli halla karli. Hanidele sne hanidele. From the sorrow, I witnessed the accused persons going away. Se kହୁଛି ମୁଁ ଦୂରରୁ ଦେଖିଲି ସେମାନେ ପଳେଇ ଯାଉଛନ୍ତି, ପଳେଇଲେ accused persons. The sorrow is about 30 to 40 cubits away from the house of Panchanan, which was visible from the sorrow. Panchanan went to his house first, and then myself and PW5 went to his house and found the dead body of the deceased lying on a cot, and a tangia was lying there, and there was a blood stain. After witnessing the dead body from the door, I came back. I came back to Sala. The accused person standing in the door.
In the dock.
Side.
We're going away.
Going away from the house of Panchanan. Then I went to my village. I have been examined by the police. Cross-examination. I could not do any work in the Sala since the occurrence took place. Since the time of my grandfather, we were working at Bartania as in the Sala of Panchanan. When I witnessed the accused persons going away, by that time, Chabi and Panchanan were present at the Sala. After the accused persons going away, we came to the house of Panchanan. Panchanan and his sons were living in one mess. After my arrival at the spot, I had not talked with anybody. I have not informed to anybody in my village regarding the occurrence. It is not a fact that I have not stated to IO. I heard at the Sala the shouting that Maridele. It is not a fact.
ଇଏ କହୁନି PW5 ମଧ୍ୟ you are right. PW1 ବି କହୁନି ହାଣିଦେଲେ ସାଇଣ୍ଡ, PW5 ବି କହୁନି। ଏଇ ୱିଟନେସ ଟା ଯଦିଓ ପୋଲିସ ପାଖରେ କହିନି ଫାର୍ଷ୍ଟ ଟାଇମ କୋର୍ଟରେ କହୁଛି। ଓକେ,
ସେମାନେ ଖାଲି କହୁଛନ୍ତି ସେ କହିଲେ କିଏ ଆସୁଛି ଆସ ଆମେ ହାଣିଦେବୁ ବୋଲି କହିଲେ, କିନ୍ତୁ ଏଇଟା ଦିସ୍ ୱାଟ ନଟ୍ ଅଟର୍ଡ ବାଇ ଦ PW1.
Hmm.
It is not a fact that I have not stated to
এই পার্টটা ଆପଣ ପ୍ରମାଣ କରିଛନ୍ତି IO2 এই ଯୋଉଟା ପଚାରିଲେ paragraph 3 ରେ PW 6 କୁ ଯୋଉଟା confront କଲେ that he said that it is not a fact that I have not stated about the south hanidele. Where is that?
examined by PW 15.
Para 9, your lordship.
Paragraph 9.
The IO has been asked that question.
I have
PW15.
the examined sworn, so he has not stated before me that he heard at the Sala the shouting of Swanso, and that he could see the accused person from Sala going out from the spot. He has stated to have seen the accused person. এই হানিদেলাটা নাই,
But we have seen.
Accused persons, one Tangia was okay, say 6 re.
Para 9, I was examined.
No, this PW 5 and 6, though they saw both the accused persons decamping from this spot,
Lordship.
but one thing appears that they have not seen any weapon in their hand. Please check it thoroughly once again, because one says that I found appellant number 1 was holding one Tangia, and then this words were uttered, and inside near the dead body another Tangia was lying. So that was seized, there is no problem. But this particular Tangia, which is stated to have been held by this appellant number 1, as stated by PW1, though these two witnesses have also seen the accused persons leaving the place, they have not saying that they have seen the weapon in their hands.
PW 5 and 6 not stated that appellant number 1 was holding.
नहीं ना PW 5 किए कोई जी
5 and 6 not
नहीं
stated.
5 and 6 you are right,
Not
not seen weapon in the hands. अच्छा बाकी ये जो तीनटा साक्षी को आमे जदी रखिबू तो आसुची 1 नंबर साक्षी कहला जे आमे सांग होइकिन गलु, whereas 5 and 6 से कहउचंदी जे 1 नंबर आगे रे गला आमे टिके पछरे गलु.
But all of the three were in Sala.
They were in
Sala.
Sala.
It is quite nearer to the spot.
And this one has stated that he heard in the cross-examination, he heard accused person saying, "Kiye asuchi aso from his Sala." And I found Purushottam was wearing a lungi at that time. I cannot say what Karno was wearing. When we reached at the spot, both the accused persons fled away. So this is one part of the evidence which has also been accepted by the trial court about the evidence of the only part we find that this holding of Tangia by the one of the accused, that is appellant number 1, though deposed to by PW1, is not there in the evidence of.
But one strong circumstance is that both the accused persons were seen
leaving the place
nearby this spot,
and at
they were
that
leaving.
point of time the deceased was lying with a number of injuries on the cot, and one Tangia was there. But if they left one Tangia, let us see, why then they will carry another? They could have carried both the Tangia with them.
Was at the spur of the moment.
No.
When they have
just
committed
think
murder of
it.
their own cousin.
If they want to take away the Tangia just to cause disappearance of evidence, right? If that was their intention, then why did they leave one Tangia and carried another? Prosecution is not that the prosecution is trying to put something to show that yes, the accused persons were armed with a weapon, which is not the consistent case of 3 witnesses have seen them leaving the spot. 2 have not seen any weapon, 1 has seen. And this Tangia theory, which is stated to be seen by the PW1, can it be whether it is acceptable when they are leaving one Tangia and they could have left both of them, or they could have carried both of them, leaving one Tangia, and that also one of the features. Just think over it. We are not but presence is there. Presence is there. Leaving the spot is there, and some kind of contradictions between these 3 witness. କିଏ ଆସୁଛ ଆସ ସେ ଯୋଉ ୱାର୍ଡିଂ ଟା ରହୁଛି, ଯେହେତୁ ସିଏ କେବଳ କହୁଛି ଯେ ହଁ ସେ ପ୍ରଥମରେ ଚିଫ ଏକ୍ସାମିନେସନ ରେ କହିଲା ଯେ ମୁଁ ସ୍ପଟ କୁ ଆସିଲା ପରେ ଏ କଥା ସେ accused କହିଲେ, କହିକିନି ପଳେଇଲେ. Kintu whereas in the cross examination he says that while we are at Sala, just come to that line, page 43, page 43 ର ଯୋଉ second line, first line କହୁଛି I heard the accused person saying କିଏ ଆସୁଛ ଆସ from my Sala. So ସେଠୁ ସେ ଶୁଣିଲା. And this is not corroborated by the other 2 witness. 5 and 6 ସେମାନେ କହୁନାହାନ୍ତି ଯେ କେହି କହିଲେ ବୋଲି accused persons while decamping or stated anything. So ଏଇ 3ଟା witness କୁ ଆମେ ଯଦି analyze କରିବା, what is ଗୋଟେ consistent version ଆସୁଛି ଯେ deceased was lying inside that room with injuries. One Tangia was there which was also seized, and both the accused persons were decamping from the age part at least consistent aschi. Se utterance re kon kahile, there is some kind of discrepancy, and holding of Tangia by appellant number 1 at that point of time, there is also discrepancy. Otherwise au baki part ta as we find it is consistent. So what you say about this aspect? We'll go to the other evidence. ଆପଣଙ୍କର what is your submission?
Admittedly, my lord, none of the witness was there at the
No, there is nobody saying that there is any eyewitness to the occurrence.
of occurrence. On hearing sir, PW1 stated that he at the time of occurrence he was at the Sala, and which is 30 to 40 years from the spot. And hearing south, he came to the spot and saw that
Followed by PW 5 and 6. He says I went along with them, but the 5 and 6 say that we followed them.
And they have not seen the actual assault. They see the
assault.
No, don't go to the assault part.
assault କିଏ କହୁଛି assault?
PW1
Trial court ମଧ୍ୟ କହୁନାହାନ୍ତି assault, କି ସେମାନେ ନିଜେ ବି କହୁନାହାନ୍ତି ଆମେ assault ଦେଖିଛୁ ବୋଲି. ଆପଣ ସିଆଡୁ କାହିଁ ଯାଉଛନ୍ତି? ଆପଣଙ୍କର ଏଠି ଗୋଟେ circumstantial evidence ଯୋଉଟା ରହୁଛି, ଏଇ ଯୋଉ presence of the accused immediately at the scene of the occurrence, ହେଲା? ତେଣୁ that is one of the circumstance against you. It's not so that ସେଇ circumstance ଉପରେ ଆପଣଙ୍କର comments କଣ ଯେ କାହିଁକି ଏଇ 3ଟା witness କୁ disbelieve ହବ? We want to know from you your argument on this particular point, that why these 3 witnesses evidence that they had seen the accused persons decamping from the spot where the dead body was lying inside that house with injuries and Tangia was there, why these 3 witnesses would be disbelieved. Whether that would be sufficient or not, that's a different matter. But why we want to your argument? 3ଟା ସାକ୍ଷୀ ଗୋଟେ point ରେ କହୁଛନ୍ତି ନା, ତ ଏଇ part ଟା କଣ ପାଇଁ disbelieve ହବ?
They are not the PW 5 and 6. They are not the village of the
No, identity is not a question here. They know these two persons.
Yes,
Their case is that they had come to that sala of
They used to come,
they used to
PW1,
come.
PW5 used to come.
ତେଣୁ ସେଇ ଇଏରେ ସେମାନେ ପ୍ରେଜେନ୍ସ ଆସୁନି ଆଉ and the time is the occurrence took place
Not
at
like
a
morning.
on the ଖରାବେଳେ ତ time ହେଇଛି so identity it's not a factor nor anything you have put that you do not know
them. That
case
is also not your case.
that is not your case is that accused persons are known to everybody 1 5 6 identity is not disputed and time of occurrence is such that it's not improbable on their part that they cannot see that so that part is there. Okay, so this part is there. Then what are the other evidence as we find? Come to the, we have gone up to PW6. So let us see what are the other witnesses have stated. PW7 you come to.
PW7 matter.
Hmm.
the night. Grammar page 56.
Please continue. Yes.
I am the grammar of village Keravari, and I also belong to village Keravari. I know both the accused persons standing in the dock who belong to my village. I also know the deceased and the informant. About 2 years, 1 month back, Robbie died. Due to assault by the accused person. On this date of occurrence, the father of deceased, PW1, had gone to call me. I came to the spot at about 5 p.m. and watched the dead body of Robbie, which was lying in the house of Panchanan. There was cut injuries in her throat, chest, and belly. There was also profuse bleeding, blood stains throughout the room. One Tangia was lying near the cot. In the night, the Thana Babu arrived at the spot. I was the dead body.
Whole night as per
the whole night as per direction of Thana Babu. After the inquest was over, on the next day, command certificate was issued to take the dead body for PM examination. After postmortem, I produced the lungi of deceased and the command certificate before Thana Babu, which was seized by him. He also prepared a seizure list. This is the shared seizure list by the exhibit 4. And exhibit 4/1 is my signature. Ramo Naik Grammar was also present. He has also signed on exhibit 4. The wearing apparels of the accused persons were also seized by Thana Babu in my presence, and a seizure list was prepared. This is the shared seizure list marked exhibit 5. This is my signature marked.
So he basically is a seizure witness and also a witness who had carried the dead body for the postmortem examination, right? Okay. Now come to the next witness.
PW8.
Yes.
PW8. I know the accused persons in informant and the deceased. Police made inquest over the dead body and deceased dead body of deceased in my presence. This witness the witness to inquest and prepared a report. I have seen the dead body lying in the house of the Panchanan on a cot. One Tangia was lying nearby. This is the inquest report prepared by the IO, already marked exhibit 2. This is my signature. They are all marked as exhibit 2/4. I found the dead body with cut injuries on his throat and chest. Bloodstains earth, sample earth, and the Tangia lying at the spot were seized in my presence, and this a seizure list was prepared. This is the seizure list marked as Exhibit 3, and this is my signature marked as Exhibit 3/2. Village Sarpanch was also present at the time. At that time, cross examination. One chadar was put.
Leave that, leave that. So he was just a witness to the seizure.
In
Come to the next witness. Okay.
next witness, doctor.
Okay, doctor.
PW 9.
So let us see the injuries. Chop wound.
4 injuries, my lord. Inside 3 are
Okay, on the neck. Okay. Then
3 injuries are choke injury, and injury number
twisted right console. Incised wound on the middle of the chin. Okay. And injury number 1 caused immediate death
the
due to
above
stoppage of
injuries are
respiration.
anti-motor in nature, except injury number 4.
Hmm.
All the 3 injuries are grievous. Grievous. Injury number 1 caused the immediate
Death due to stoppage of the respiration.
due to stoppage of respiration during
And
Duration of
all the injuries are caused by sharp cutting heavy.
anti-motor.
heavy.
Okay. Cause of death here he has stated to be due to stoppage of respiration and hemorrhage. All right. And death is homicidal. Okay. Now, para 2 he has stated to have perhaps, yes, examine the weapon, and
Para 2.
two acts were produced before him, as it appears. So he opined that injuries found on the body of the deceased could be possible by the above weapon. So both the weapons, he says, it is possible. Okay, then collected nail clippings, so and so. Okay.
Cross examination.
This is a homicidal death. It's not disputed about. Now you come to the next witness, PW10.
PW10. I know the Ramachandra name. I know the informant. I also know the accused persons standing in the dock. I came to know I came to know from Pachanan Pradhan that his son was murdered by both the accused persons. Then I went to the spot and found the dead body of the deceased was lying on a cot, sustaining cot injuries on his throat, chest, and belly. And I
Formal witness, you leave it. Come to the next one, PW11. Photographer. So is leave it. Next, come to PW12.
PW12 Malad IO of Harbanga.
Okay, one of the investigating officers. There are 2 investigating officers in this.
For whom they surrendered.
Extrajudicial.
Yeah, not.
Please read it. Yes, sir.
On 4/8/2004, I was OIC of Harbanga PS. On that day, I had gone
To attend crime meeting.
Crime meeting at SP office at both. At the time of their surrender, he was absent. The PW 13 and 14 were present.
No, let us see this.
Yes,
Proceed.
at about 3 p.m., I received a message from Constable Hajari Naik, PW 13, and Havildar
Rajkishore
Jali, that 2 persons of
Rajkishore is PW 14.
14.
Okay.
13 and 14.
Okay.
Daspala, the 2 persons from Daspala side surrendered inside the PS at Harbanga. They disclosed their name to be Karna Pradhan and Purusottam Pradhan, a village Keravadi under Daspala PS. The constable also informed me that they both have confessed to have killed one Ravi Pradhan of their village. After receiving this information, I ran to the OIC Daspala and disclosed the fact before the
before him.
Before him. I also issued instruction to the constable to keep the persons, both the accused persons, in safe custody till my arrival. After my arrival, this same night, both the accused persons disclosed their names and addresses. I ascertained the facts from them. I also found an axe with them, which was separated from the handle. Their wearing apparels were bloodstained.
Mm.
In the same night, Y.C. Daskola arrived there after entered the fact in diary. I handed over both the accused persons to the Y.C. Daskola.
Mm.
On same day, a station diary entry was entry dated 4/8/2004 was made by Hajari Naik. I am well acquainted with the handwriting of said Hajari Naik. This is the said relevant entry at page 447671 marked as Exhibit 12. This is the signature of Hajari Naik marked as Exhibit 12/1. My direction has been entered in the station diary by entry number 64 of the 64 dated 4/8/2004. This is the said entry bearing signature of Hajari Naik marked as Exhibit 12/2. The accused persons are the said persons, those who are detained at PS, Harbanga PS. Cross examination by defense.
Okay, we come to the next witness. Yes, 13 and 14. Those two Havildar or constable, whatever it means. Yes.
Rajkishore Jali, the
PW 13.
On 4/8/2004, I was constable attached to Harbanga PS. Hajari Naik was the sentry. On that day, two persons, namely Corno and Purushottam, came to the PS and told to sentry Hajari Naik regarding commission of murder of their brother. They said two persons are the accused persons who are standing in the dock today. Identified both the accused persons, both Hajari Naik and myself, confined them in custody. After their personal
Search.
one Tangia was with them, which was also kept in the PS. We watched them till arrival of the YC Harbanga PS.
Where is that statement that they confessed? Nothing is there. Came to the PS. Told to the sentry Hajari Naik. Taku Koile. Hajari Naik means PW 14.
14.
Okay. Regarding commission of murder to their brother.
They
Okay.
have confessed before the two.
PW 14, but he said that okay.
14 my lord. On 4/8/2004, I was attached to Harbanga PS as constable. On that day, I was on sentry duty. Both the officers had gone to Boudh to attend crime meeting. On that day, at about 4 p.m., two persons arrived at the police station with a tangia and confessed before me that they committed murder of a person and requested to
Save them.
On my interrogation, they expressed that out of fear they had come to a distant place. I detained them and intimated Bodababu over VH. He directed me detain both the persons in custody till his return. They were wearing lungi and gamucha. The lungi were stained with blood. The tangia was separated from the iron portion. I also entered the fact in the station diary entry by entry number 63 dated 4/8/2004. This is my signature thereon, already marked as Exhibit 12/1. I have also made entry entry number 64 at 4/8/2004 is my signature thereon with the entry. Already it's marked as 12/7. 12/7. In the
So-
same night,
So if suppose let us say in view of section 25, the first one is taken away, but one conduct is there that is also relevant under section 8 that you produced, both of you are producing the that weapon Tangia produce करना पूछो ना
separated from the 100.
ये PW one Tangia was right. So both of them have stated that Tangia was produced, which was sent to the doctor, and you find that the injuries are possible. And not only that, your wearing apparels were stained with blood. That was also seized. And as we are going through that perhaps those were found to have contained human blood. Lungita, Lungita.
Report is negative, Your Lordship.
Report negative. No, come to page number 87, the examination report.
Lordship.
Chemical.
गोटे आक्स पठाइछि जोटारे ह्यूमन ब्लड अछि लुंगीटा का रेट ऑफ द डिसीज्ड हां अच्छा ओहो blood
That
stain
axe is the axe which was found at the spot.
blood stain, you are right. So this seizure though it was made but no blood stain. So this is the evidence of PW 14. And what about the last witness is PW 15, na?
15, madam. The IO of Daspala. Yes.
So he has stated where he received this report. He said on telephonic information from one so to the effect that on the murder.
On 3/8/2004,
I entered the fact.
I was Daspala PS. On that day at about 8 p.m., I received a telephonic information from one Prasanna Behera.
Prasanna Behera examine
No, madam.
Yeah.
Of Hanumantia to the effect that one Korna Pradhan and Purustam Pradhan of Keravari have murdered one Ravi Pradhan of that village. I entered the fact in the school of SHRI entry number 57, and at about 9 p.m. proceeded to the spot. At about 11 p.m. I arrived at the spot and found the dead body of deceased
evidence sir.
Rabindra Pradhan was lying on the charcoal with pool of blood on the ground, and an axe stained with blood was lying near the dead body on the ground. There was cut injuries on the right neck, right chest, right side belly. I guarded the spot through my staff. At about 11:45 p.m., one Vikram Pradhan presented a written report before me at the spot. This is the said report.
We also say that it is reported at the spot. First, it was given, some information was given. He made the station diary entry. Then he came to the spot where the written report was presented, and written report was obviously scribed by the other person and at the. So this is basically the evidence on record. So now, what is your submission, Ms. Das? Is the party?
Well, the chemical examination report is Page 87.
That is negative.
That is,
No, what is not there, leave it.
yes.
What is there, you argue that whether it's a case where, since it's a case based on circumstantial evidence, whether the chain is complete or not, that we have to see.
Yes, sir.
Today also we delivered a judgment on the circumstantial. My esteemed brother has authored that judgment. You can go through it. So here is a case, there is no eyewitness, right?
Yes.
So case based on circumstantial evidence. So as we find, the spot is not disputed.
Yes.
Okay. And in this spot, the dead body was found, right?
Inside.
And dead body was found with number of multiple injuries are there on vital part of the body. And it is a case of homicidal death. That is also no challenge to that effect. And another thing is that one tangia was lying at the near
Spot.
the dead body. So that is also nobody challenging. Tangia seized. Okay. Now, 3 witnesses have come forward. That is 1, 5, and 6. Those who have seen the accused at the spot. Spot means near
the spot.
Some say that it is at the door, some says it is the courtyard or
Going away.
going out. Okay.
Yes.
So, so far as the holding of weapon is concerned by one of the accused, as stated by PW1, we find that that is not corroborated by the other 2 witness, that is PW5 and 6. And कौन से जो wording टा होची कि आसचो आसो देखी हानि दबु ना कौन?
Yeah, आसो हानि देबो. That also not
that is also not corroborated by the other witness.
Yes.
That is one, the next circumstance. Then about your approach to those 2 constables in the police station.
In a different police station.
And then making confession and also the producing that
one tangia.
So that tangia, of course, that was not perhaps that was not sent for
chemical
one tangia was
No,
sent.
both of them.
Both of them
the tangia which was found at the spot. From that human blood was
blood has been recovered.
Not from the
Not from the other.
And of course, your wearing apparels, there was no blood stain.
No blood.
What would be your argument of whether these are the circumstances which has been relied upon by the London trial court to convict the appellants? So, what are your argument that why we will not act upon the circumstance, or according to you that even if these circumstances are there or accepted, it cannot make the chain complete. There is some missing link. What is your submission?
Well, there are 15 number of witnesses have been examined in this case. So both the appellants are at the spot. It is not disputed also. There PW1 stated the father of the deceased. He has seen both the accused persons at the time of occurrence. Actually, admittedly, nobody has seen the assault. After the assault. Sorry,
it is not a case of direct evidence. We are yes.
My humble submission is PW5 and 6, not corroborated the evidence of PW1. PW1, as per the prosecution case, my lord, both the
corroborated means only one aspect. That is about that holding utterance and
the holding
that
of
holding
tangia.
of tangia. Otherwise, the presence aspect or decamping from the spot, leaving the spot, that is from these 3 witnesses, that part is remains consistent. That is why we asked at the first point of time, what is your comment on this particular circumstance? Dead body was lying inside the room with injuries.
it is
Tangia was
ma'am.
there, accused persons leaving this spot.
But the PW5 and 6, they have not stated that PW1 was holding Tangia.
କହିଲୁ
Yes,
ପରା Tangia part ରେ ଏବଂ not only Tangia ସେ ଯୋଉ utterance ଟା PW1
Utterance,
କହିଛି,
yes, ma'am.
there is also discrepancies.
PW6 also said that Hanidele, that also not corroborated by any witnesses. And as per the prosecution case, they have both the accused persons fled away from this spot, and they have surrendered before PW 13 and 14. PW 13 and 14, they are the constable of
And one Tangia was also seized from
and also one Tangia was seized from them. They have produced and surrendered to save them. As per their evidence, the statement of the PW 13 and 14. And no, they have confessed before the police. The police personnel, the PW 13 and 14 are really their police personnel. They have surrendered before them, and confessional statement was made by before them.
Okay.
They are also that is also not admissible in evidence by the prosecution, my lord.
No, that is taken as a weak piece of evidence. We can't take
Weak
it
piece
that
of
you cannot.
evidence. Yes, my lord. But
Yes, weak piece of-
the doctor stated, my lord, the as per examination report of the acts, he stated that the injury may be possible by the
homicidal death
death
disputed
is homicidal. Death is homicidal. It is not
homicidal death disputed ନୁହେଁ ଯୋଉ weapon produce ହେଇଛି, doctors have also stated that these injuries are possible by those Tangia. It is possible. What injuries ଅଛି obviously Tangia ଦ୍ୱାରା possible ହବ ବୋଲି doctor examine କରି କହିଛି, but one of the Tangia ରେ blood stain ନାହିଁ, ଗୋଟେ Tangia ଯୋଉଟା କି ସେ spot ରେ ଅଛି. So ଏଇ circumstance ଯଦି ଆସିଲା ଆପଣଙ୍କ against ରେ, so ଯଦି if we accept that these are the circumstances proved against you, whether the chain is complete or not,
chain of
and if
circumstances
not, why not?
has not been completed, my lord. Extrajudicial confession before police, my lord. Hence, there is no other independent witness. They have confessed their guilt. And this apart, my lord,
Now, was there any scope for an independent witness at that point of time? Because they have entered the police station directly. Where is the question of independent witness there?
While they are proceeded to the other village, they must have disclosed the fact before other independent person or before the police also. They have also before any independent witness, they have them.
No, what you say that
There is no absence of
ଯୋଉ ସେଇ ତିନି ଦି ଜଣଙ୍କ ପାଖରେ ଯାହା ଆସିଛି ସେଇଟାର ତିନିଟା ପାର୍ଟ ରହୁଛି, ଗୋଟେ ହଉଛି କନଫେସନାଲ ପାର୍ଟ, ଦ୍ୱିତୀୟଟା ହଉଛି ଟାଙ୍ଗିଆ ରିକଭରି ପାର୍ଟ, ତୃତୀୟଟା ହଉଛି ତାଙ୍କର ୱେରିଂ ଆପେରାଲ୍ସ ସିଜର ପାର୍ଟ. ये वेरिंग अपैरल्स आउ ए जो टांगिया ए दीटा पार्ट रो जेहेतु ब्लड स्टेन आसुनी से हाँ ये रे सेटा आपण कहउछन अदर पार्ट को आपण कहउछन इन व्यू ऑफ सेक्शन 25 of the evidence act, no importance should be attached to on that. That is your submission. Okay. What according to you that if these circumstances are accepted
chain of
by
circumstances not completed in this
complete
case.
that is your submission.
Yes.
Any citation you want to?
Today I have not brought any citation.
आपण आर्गुमेंट करिया आछन आउ कोन गोटे दिन एटा सार दी जिवे आउ गोटे कोन in similar circumstances many of the decisions are must be there.
Yes, sir.
Suppose the accused persons are seen decamping from the spot where the dead body was lying. These accused persons were coming to the police station, making confessional statement, producing the weapons. So how that is to be assessed by the court? What is the whether which part would be admissible, which part is not? ଆପଣଙ୍କର ସେଇ part ରେ କେତେଗୁଡା case ଅଛି including our High Court also
Yes, sir.
accused କଟା ମୁଣ୍ଡ ଧରିକିନି weapon ଧରିକିନି ଆସିକିନି police station ରେ ପହଞ୍ଚିଛନ୍ତି
Surrender କରି
confessional statement କରିଛନ୍ତି ସେଠି ଏବଂ କୋଉ part ଟାକୁ court କହୁଛନ୍ତି believable ହବ ବା acceptable ହବ in law କୋଉ part ଟା ନୁହେଁ ହେଲା
sir.
ସେମିତି accused persons were seen decamping from this spot sometimes with the weapon sometimes with not weapon ସେଠି କେମିତି analysis ହେଇଛି ଆକୁ ଯଦି decisions ଆପଣ ବହୁତ decision ଖୋଜିଲେ ପାଇ ପାରିଥାନ୍ତେ ଆପଣ ଖୋଜିଲେନି କଣ ପାଇଁ ଏ case ଆପଣଙ୍କୁ interest କେବେଠୁ ଗଲା 2008 ମସିହାର case upon and you are regularly doing these jail criminal appeals you have been entrusted with so many jail criminal appeals so and it's a case under section 302 on your argument the life of two persons depend so that sort of thing you should keep in mind and prepare accordingly
Sir.
merely because it's a jail criminal appeal you should not make any lack of preparation they have nothing that is why they were not able to engage any counsel private counsel on their own so that is why they have sought the assistance of the legal aid board and when the legal aid board has entrusted you is it not your duty to prepare the case and brought the citations memo of citations and written note of submission
I have not prepared written notes of submission. My lords, permit me, I will submit by
permission kon apan
by tomorrow, day after tomorrow, I will submit.
yes already please tell yes Mr. Mishra
Lordship. Lordship, here there are 4 circumstances
yes
as per the prosecution.
what according to you are the circumstances
Lords, the first is that the death of the deceased. As per the postmortem report, that is PW9, there are 4 wounds on the body, out of which 3 are chop wounds.
homicidal death you mean to say not
Yes.
disputed
Not disputed, and that is the first circumstance, Your
Okay.
Lordship. Then the second circumstance, Your Lordship, is that there was clearly a dispute between the accused persons and the deceased, Your Lordship. If Your Lordship may take the version of PW1, Your Lordship, at page number 42,
just a minute
Lordship.
who are the witnesses first tell me we'll go to that about this circumstance you are telling that there was dispute between the appellants and the deceased
Only PW1 has stated.
PW1 has stated okay let us go to that part only
Lordship.
because we have
Page 42,
page 40
Lordship's meeting.
okay yeah
Paragraph 3, Your Lordship.
yes
The third line of paragraph 3. On the date of incident, my deceased son had gone to the land of the accused persons to cultivate the land on bhaga basis, but he was restrained by the accused persons. My son came away since I restrained. After his arrival in my house, I went to the sala.
ଏଇଟା କଣ ସେ କହିଲା ଯେ ମୋର ପୁଅ ଯିଏ ମରିଗଲା ସିଏ ଯାଇଥିଲା ଭାଗ ଚାଷ କରିବା ପାଇଁ ଆକ୍ୟୁଜ୍ଡ କର ଲ୍ୟାଣ୍ଡ କିନ୍ତୁ ତାକୁ ଆକ୍ୟୁଜ୍ଡ ମାନେ ଆଲାଉ କଲେନି ବା ରିଷ୍ଟ୍ରେଣ୍ଟ କଲେ ସେଥିପାଇଁ ସିଏ ଫେରି ଆସିଲା
Lordship.
ଏଇଆ ତ ଏଭିଡେନ୍ସ ନା
And one more thing, Your Lordship, that is at page 44 in the cross.
44 ଅଛି
The fourth line from the bottom, Your Lordship, para 7. He was posed a question, and this is his answer, Your Lordship. It is not a fact that out of previous land dispute, I have falsely entangled the accused person in commission of the crime, and that somebody else has caused the murder of my son.
ହଁ ସିଏ କହୁଛି ଏଇଥିପାଇଁ ଫଲ୍ସ ରେ ବଟ୍ ଏଇ ଯୋଉ ପାର୍ଟ ଟା ଆପଣ କହିଲେ
Lordship.
you come to the evidence of PW2 see
lord.
that what is his evidence PW2 is the obviously the brother of the younger brother no elder brother of the deceased right जिस paragraph 2 रे पढ़ंतु आउथरे
Lordship. On 3/8/2004, Rabi died due to assault by the accused persons by means of a tangya. My mother is dead since the last 4 years. On the date of occurrence, in the morning, my younger brother, the deceased, went to cultivate the land of Yamuna Pradhan and Purushottam Pradhan since they have requested to cultivate the same on bhaga basis. There was dispute in the family of the accused persons. On hearing the fact, I went to Rabi and restrained him not to cultivate the land of Purushottam. Then he cultivated our land, and after returning to house, I went to graze the cattle.
So is it not these two statements are not completely contradictory to each other? PW1 कौन कहला बापा कहला जे मो पुओ जाइथिला भाग चासी करियाकू ताकू अक्यूज्ड माने रिस्ट्रेंट कलो हला फेरा ता भाई कहूची जे मु निजे गली से माने ताकू कहले नाइ तू चाष कर मु ताकू निजे कहली नाइ नाइ तू सेठी चाष करनी सेत पई से आमो जमी प्लीज रीड इट वंस अगेन जस्ट टू सी दैट द डिफरेंस on the date of occurrence again you read it because in a Mr. Misra, please know one thing. Whenever you are preparing a case, I find it myself also. If you go on reading the evidence again and again, you will find many things. Same thing you may not detect in the first instance, but on repeated, you can find many things from that. So it is always proper to read line by line. Don't leave, because even if one line here and there sometimes gives, you can find a point from that. Okay. So as a public prosecutor, now your duty is not to see that a man is convicted, right? Your duty is to see that proper justice is done, whatever may be. Maybe it is against the prosecution, but you are to bring it to the court, sir. This is the fact. So that should be the attitude of a public prosecutor. Okay. So now you please come to that line again.
I'll read the whole paragraph again.
Yes, no, just on the date of occurrence.
On the date of occurrence, in the morning, my younger brother, that is the deceased, went to cultivate the land of Yamuna Pradhan and Purushottam Pradhan.
Purushottam Pradhan is appellant number one, right?
My lords. Since they have requested to cultivate the same on bhaga basis.
Okay.
There was dispute in the family of the accused persons. On hearing the fact, I went to Rabi and restrained him not to cultivate the land of.
So restrain kala kiye? Mane ye nije jai taku restrain kala. Not that the accused person's restraint has been stated by PW1. Yes, restrain him not to cultivate the land. Then he cultivated our land and after. So ei jo dita evidence asila, can you say that this can be taken as a motive behind the commission of crime? Jaha evidence apna कहले ना गोटे circumstance होची dispute between the appellants and the deceased. जदि PW2 रो evidence आसीबो आमे scan करिबु ताले जणा पड़ुची as if they wanted the deceased to cultivate the land and they also allowed the deceased to cultivate them. The prevention or the restriction was imposed by PW2. He said to his brother, don't cultivate their land. There was some dispute between their family. So he said, and we cultivate our land. So age jinsotare jota dita sakhi hi apna ei particular aspect re kohchandi. So is there you don't find any discrepancies between this evidence?
So there is a contradiction of that in that particular incident.
Yes.
But your lordship, my humble submission is the
Yes.
fact still remains that both the testimonies of PW1 and 2 showcases that there was a dispute between both the parties, your lordship. Because here he has also stated there was a dispute in the family of the accused person.
Family of the accused person.
Family of the accused person.
Not any dispute between the deceased family and the family of the accused. Because deceased family, as it appears from the evidence of both PW1 and 2, is that he is a person to cultivate the land of Purushottam, not being a part of the dispute, but he was requested. See, he was requested to cultivate, and that is how he was going to cultivate. But he was restrained by PW2 because there is a dispute in family, so intra-family in the accused family, for which he was restrained not to cultivate.
Accused family bhitere dispute thila, not that accused of deceased family bhitere, that is being pointed out. So a line टा देखो तो अपन फटकिन नहीं जाओ ना that is why I would
Apparently it shows.
हाँ
When you submitted, apparently it shows that yes, there is a dispute between the families of the deceased and the accused. No, he was going for as usual cultivation, irrespective of the fact whether there was a dispute in the family of the accused. But it was detected by PW2,
right.
who said, don't go. There is a dispute between in the family of the accused, so you cultivate our land. Accordingly, he cultivated their land and returned.
Right. Okay. So next, what is the next circumstance according?
Lords, the next is the versions of PW 1, 5, and 6, Your Lordship.
Okay.
Where PW 1 has specifically stated that he went to the spot of the crime and he has, even though he has not witnessed the murder itself, he has seen the accused persons, both of them were there,
Right.
and one of them was holding an axe. Now, Your Lordship, so far as the discrepancy with regards to PW 5 and 6, that PW 5 and 6 have not seen the accused appellant number 1 holding an axe.
Accused persons holding no
Only appellant number 1.
One, that
Purushottam was holding
right.
the axe.
One was holding axe. Yes.
Lords, the version of, if Your Lordship may come to PW 5, at page 52, Your Lordship.
Yeah.
At the very last, the last line, Your Lordship.
Just a minute. PW 5. हाँ कौन तो PW 5 page number 53
52
52 अच्छा okay.
The last line, Your Lordship, meant it. I also found both the accused persons, that is Karna and Purushottam, going away from their backside when Panchanan shouted. So he clearly observed them from their backside, from behind. So it's quite possible that he could not have seen the axe with them because they were already running away.
No, they are not running away. They are going away. Again, he has not stated running away.
Yes, he has stated going away.
Going away, yes. Going away and running away, there is difference. And all right, then next.
But one thing I have led to it. Even if 3 persons were in a particular position, it is not necessary that all the 3 persons will notice the same thing in the third person. So one person might have noticed.
Observation may vary. That's right. Observation may vary. The same incident, you might focus on a particular thing. He might focus on another thing. So that doesn't mean that that thing does not exist merely because somebody. It's not that same thing.
All the 3 will
ସେଇ ଗୋଟେ ପଏଣ୍ଟ କୁ ଆମେ ତିନିଟା ଆଙ୍ଗେଲ ରେ ଦେଖିଲେ 3 ଜଣ ସେଇ ଜିନିଷଟାକୁ ସେମାନେ ତିନିଟା ଆମେ ଏଇଆ ଦେଖିଲୁ ତା ମାନେ ନୁହେଁ ଯେ ସିଏ ଯାହା ଦେଖିଲା ସେଟା ନୁହେଁ ବୋଲି so that is okay. What about PW6?
PW6 is also, he has not stated that he has seen from the backside, but he has also stated that I witnessed the accused persons going away.
Yes.
So therefore, it's quite possible that how your lordships complimented my argument. It could be very possible that these 2 persons could not have seen that, and PW1 has in fact seen that, your lordship. And if your lordship may take the final circumstance.
No, tapre you may say also ଯେତେବେଳେ ଯାଉଛନ୍ତି, it depends upon in what position they were keeping that axe. Suppose ଗଲାବେଳେ ତ ଏମିତି ରଖିକି ଯାଉଛି.
Yes.
ତ back side ରୁ ଦେଖାଯିବ. ଇଏ ଯେତେବେଳେ front to front face କରିଛି ସିଏ ଦେଖିଥିବ. That's just think over it. So that is the charm in arguing a case. That is the charm in a criminal case. So always try to corner the other side. Okay, yes, proceed.
And my submission is that PW1's witness is very believable. There might be minor contradictions here and there, but that does not confer the entire testimony as inadmissible in evidence, your lordship. That can be said for PW1, 5, and 6 as well.
Okay, this is regarding that holding axe and leaving the spot.
Leaving the spot, your lordship.
Okay.
Now, your lordship, the final circumstance is their confession of guilt before PW14.
2 witness, I think.
13 and 14. But
14
is important.
14 is important because confession was made.
Constable is important.
Right. Okay. PW14 is right.
Your Lordship, I'm aware of Section 25 of Evidence Act,
Yes.
but however, as Your Lordship already pointed out, under Section 8 of the Act, their conduct can still be taken into consideration. My
Right.
Lordship. Because in this peculiar facts and circumstances of the case where they have committed the murder of their own cousin, and after that they've fled from the jurisdiction of that village, of that PS, into the adjacent jurisdiction, and they have
No, Mr. Mr. Just think over it.
Lordship.
Producing an axe is definitely is a conduct which would be admissible under Section 8, but unless it is proved that that particular axe has been used by the accused, because nobody has seen, so the lacking part is that absence of blood stain. So only gote accused gote anikini produce kala axe, but unless you prove the other things, so sei circumstance ta kete dur incriminating habo. Suppose sei axe ru ଆପଣଙ୍କର କେମିକାଲ ଆନାଲିସିସ୍ ପାଇଁ ଗଲା, ସେଇ ଆକ୍ସରୁ ଯଦି ହ୍ୟୁମାନ ବ୍ଲଡ ବାହାରିଥାନ୍ତା, ହେଲା, ତାଙ୍କର କପଡା ଯୋଉଗୁଡାକ ପିନ୍ଧିଥିଲେ ସେଗୁଡାକର ହ୍ୟୁମାନ ବ୍ଲଡ ଆସିଥାନ୍ତା। ତ ସେଇ ଯୋଉ ଜିନିଷଟାକ ଆପଣ ପ୍ରମାଣ କରିଛନ୍ତି ବାଇ ୱେ ଅଫ ଦ୍ୟାଟ କେମିକାଲ ଆନାଲିସିସ୍ ରିପୋର୍ଟ, ସେଇ ଯୋଉ ପାର୍ଟ ଗୁଡାକ ଯୋଉ ଏକ୍ସକ୍ଲୁଡ କରିଦେଇ ଚାଲିଗଲେ, ତେଣୁ it is no doubt a conduct, but how far that conduct can be utilized in this case for convicting or for making that the chain complete. So upon this is okay that one axe was produced. So this is any other circumstance you find
this axe is justifiable in my humble
Yes.
submission, because it vis-a-vis the submission of PW1 who has seen Purushottam holding an axe.
no, you just see that he has not identified the axe. Please come to that PW1's evidence. He says
It was not produced then.
no, he has made a statement that this is not that axe. Yes, yes, that is not produced. Somewhere he has stated. Cross examination କୋଉଠି ଗୋଟେ କଣ ଗୋଟେ କହିଛି ଆକ୍ସ ବିଷୟରେ ଗୋଟେ ପଚାରିଛନ୍ତି ତାକୁ, ସେ ମନା କରୁଛି ଯେ ଏଇ ଆକ୍ସ, where is that line, Mr.
No,
Tripathi?
sir, he has made it very clear that I am not witnessing this at Tanyan. It was not. I am not witnessing.
Acha, ye line.
It was not
The
produced.
first line, yes.
It was
First
not
line of
produced.
the
So he is a person, you see, he is a person who is supposed to have, according to the prosecution case, witnessed that Tangia. And the Tangia was available in the court because it was produced at the latter point of time. And this witness was also further cross-examined on another date, on 27/10. He was called almost after a month. So if by that time also number of witnesses have been examined.
This Tangia could have been.
Tangia could have been shown to that witness. ଆପଣ ଦିଟା ଯାକ ଟାଙ୍ଗିଆ ଆପଣଙ୍କ ପାଖରେ ଥିଲା, ମାନେ ଯୋଉ ଦିଟା ଯାଇଛି ସେଠିକି, ତ ଆପଣ ସେଇ ୱିଟନେସ୍ ଟାକୁ ଆଣିକିନି କନଫ୍ରଣ୍ଟ ପାଇଁ କରେଇଲେନି। ଆପଣ ସେ ବର୍ତ୍ତମାନ ସେ କହୁଛି what has been rightly pointed out that ମୁଁ ବର୍ତ୍ତମାନ କୋର୍ଟରେ ସେ ଟାଙ୍ଗିଆ ଦେଖୁନାହିଁ। Obviously, perhaps it was not produced from the Malkhana. Maybe that may be कि कौन ହେଇଛି proper state of mind, କିନ୍ତୁ ସେ ଟାଙ୍ଗିଆ ପରେ ମାର୍କ ହେଇଛି, MO ହିସାବରେ ମାର୍କ ହେଇଛି ନା?
Yes, it has been marked.
It is marked.
So MO3.
So that is what in a trial it is always ensured before the trial starts that the MO is produced. It's a very important aspect in the trial. Probably the court has not remained oblivious to this.
तो जो सबमिशन टा आपण कहले जे सेई टांगिया को PW1 कहूची, आपण लिंक आसुनी ना, आपण जो लिंक आपण जदी एस्टैब्लिश करथांदे, जदी मन करंतु ये करथांदे सेई जो दीटा पुलिस ऑफिसर से माने कहिथांदे एटा होची सेई टांगिया जोटा की अक्यूज्ड प्रोड्यूस कले से दिन, एवं PW1 कहिथांदा एई टांगियाटा को मु देखिथिली A1 हाथरे, अर्थात अपेलेंट नंबर 1 हाथरे। आपनकर देखंतु
Have these witnesses seen PW14? No.
PW14 has also not stated. जो टांगियाटा ता जरिया रे प्रमाण करि
No, I
परथाते ना,
think that is he has said, sir.
stated. टांगिया विषय
In the same night, 7:30 p.m.,
Yes, he has stated your
he
lordship.
stated
हाँ MO3
Page 70.
MO3.
MO3 is the टांगिया
said
which
Tangia.
हाँ ସେଇ MO3 ଟାକୁ ଆପଣ ଯୋଉଟାକୁ ଯଦି
PW1.
ଆଣିକିନି PW1 କୁ ପଚାରିଥାନ୍ତେ ଲିଙ୍କ ଗୋଟେ ଆସିଥାନ୍ତା ଯେ ଯୋଉ ଟାଙ୍ଗିଆଟା ଇଏ ଦେଖିଥିଲା ହାତରେ ଏ ଆପେଲାଣ୍ଟ ନମ୍ବର 1 ହାତରେ ସେଇ ଟାଙ୍ଗିଆଟାକୁ ଏଇ ଆପେଲାଣ୍ଟ ଆଣିକିନି ଥାନାରେ ପ୍ରୋଡ୍ୟୁସ କରୁଛି ଯଦି ଏଇ ଏଭିଡେନ୍ସ ଟା ଆପଣ ନ ଆଣିଲେ PW1 ରେ ତାହେଲେ ଖାଲି ରହିଲା କଣ ନା ଗୋଟେ ଟାଙ୍ଗିଆଟାକୁ ନେଇକିନି ସେମାନେ ଦି ଜଣ ଆକ୍ୟୁଜ ପ୍ରୋଡ୍ୟୁସ କଲେ ଯୋଉ ଟାଙ୍ଗିଆରକୁ କିଛି କୌଣସି ବ୍ଲଡ ମିଳିଲା ନାହିଁ now let us say accept all these things जो वर्तमान आपण जे एई चारटा ना आउ किछि आपनकर circumstance आपण पाउछंती
And that confession part, your lordship, which is also part of the circumstance number 4, that even if we neglect the surrendering of the Tangia, they have still confessed to PW14 that they have in fact murdered, and because they had expressed fear, they had come to a distance.
So you want to say that this confessional statement is also to be acted upon
Under section 8, your lordship, because the
confessional
conduct
conduct is that is section 8, that is that production of Tangia and their appearance and their that seizure of all these are comes with
Together.
but this confessional part it comes to that section 25. Right?
Yes.
So what you want to say that in view of the bar under section 25, where the language, let us read that language once again.
25. May I read it out, your lordship?
Yes, please.
Section 25. Confession to police officer not to be proved. No confession made to a police officer shall be proved as against a person accused of any offense.
So see the language. No confession.
No, yes.
Exception is only, there are two sections. 26 is one section and 27 is another section. The 26 says that no confession made by any person whilst in the custody of the police officer unless it is in the immediate presence of the magistrate shall be proved. It says 27 obviously एटा नहीं कारण ता बेसिस रे जदी कोनसी leading to discovery ହେଇଥାନ୍ତା 27 ଆସିଥାନ୍ତା ଏଠି simple ଆସୁଛି 25 ଏଇ ବିଷୟରେ ଆସୁଛି ତେଣୁ 24 is an exception to the other persons. 25 is the restriction for the police officer. So, okay, we are noting down your submission. Okay, so you have pointed out 5 circumstances before us or any other circumstance.
No, that's all, your lordship.
That's all.
These 5 circumstances.
Now, since he is asking for time till tomorrow to cite some decisions, you may also,
If she can bring it tomorrow.
you bring it tomorrow, search it, and you also find out if
I have some citations with me, but I'll produce it before your lordship
tomorrow on any of these circumstances.
Lordship.
The principle don't give the citations. There are number of decisions. Today also we have delivered a judgment. My brother has authored that judgment. So that principle, not that conscious law about this decisions. So everything is settled. So, but on these facts of this case, you find this decision. Okay. So ଏଟାକୁ କାଲି ଆପଣ ପ୍ରଥମରୁ ଡାକିବେ ହେଲା
Tomorrow,
No, don't take time.
Right, because we have already taken it tomorrow. We'll take it.
So please, Yeah. Yes. Set of someone. So, rest of the matter we take up. Yes, whereas that vigilance matter, where because of a wrong statement, that charge has been framed, your lordship call for a report, matter was adjourned again and again. And it's a fresh admission matter. Before vacation, your lordship went out of list. Now the case is posted to 4th. So may I pray tomorrow or day after? You file the memo, Memo I have filed, but unless your lordship says it won't come tomorrow. No, it is not possible this week. It will come on Monday. 4th the case is posted. It will take time. So. Report न मांगले जाए तो लोगों ठीक थिले. और High Court report मांगला पर जाहुए your lordship knows that better. Yes, sir.
I may be pardoned to
Tomorrow or
make a
day after.
mention. I may be pardoned to make a mention, Your Lordship. Your Lordship, in our BL appeal, we had been directed to deposit 73 lakhs, out of which we have deposited more than half of the amount, Your Lordship. In the meantime, we seek some waiver as the case is posted on 4th in the court in session, Your Lordship. We have filed a modification to that effect, if Your Lordship will consider it before 4th.
Yes, Mr. Shyam.
Much obliged.
It's a bail application. It was listed before vacation, my lord. And my lord was about to take, my lord. And now the matter is not in the list. Similar matter of the same case, co-accused persons, has been listed on the coming Friday. Item number 24 and 101. May I pray to be taken up?
Give it. So, call the matters.
Supplementary list item number 2.
This time is allowed, huh? Yes.
Item number 3.
May plus man. Here, I filed an IA for recall of the order dated 23/6/2023. My lord, kind of relax.
Yes.
That bail application in respect of another accused, I have given to lordship granted bail to that Sheikh Juma. Not the petitioner has granted bail.
Right, IA number. Mr. Tripathi.
A copy not served, my lord.
IA copy दियो. IA number 1200 of 2023. This is an application for recall of the order dated 23/6/2023. Learned counsel for the petitioner submitted. that the bail application was disposed of on 23/6/2023 with an observation that the petitioner has already been released on bail in connection with this case in BLAPL number 2903 of 2023 in absence of the learned counsel for the petitioner. However, the said BLAPL number 92903 of 2023 was not of the petitioner, but it is of the co-accused Sheikh Juma alias Sheikh Jumana. And therefore the order may be recalled and the bail application be heard on merit. Learned counsel for the petitioner produce the order copy of the order dated so and so, passed in BLAPL number 2903 of 2023, which is taken on record. Learned counsel for the state has no objection. Considering the submission made by the learned counsel for the respective party, the order dated 23/6/2023 stands recalled. Matter will be listed before the assigned bench. I.A. disposed of.
Item number 4.
For modification of the order, the date of the order has been so rapidly typed as 19/10/2022 instead of 2023.
Yeah.
In the order date has been wrongly typed as 19/10/2022 instead of 23.
23, it would be 23.
Yes, ma'am.
Yeah. लिखी देवे जोड़ा. Yeah. Order check.
Item number 5.
My lord, the year has been wrongly mentioned as 2022 in the order, my lord, basically the top of the order. That is the only thing.
So your witness is ready. And where is the counsel for the the weekly list matters are all hearing matters, huh? Why don't you please give information to Mr. Kanungo or Milan Kanungo or Mr. Agrawal so that they can come and we can state our stuff. Bahar boschen to Dakuran. Baki also. To G, so gang rape case. Okay. So there are altogether how many persons were who faced trial and how many persons were found guilty?
3 persons were faced
Yeah.
trial and all the 3 were convicted.
Just a minute. Just a minute. Okay, 3 persons face trial. And
Item 1, my lord. Quickly list item 1.
Hmm.
And then the CRL is instituted to appear, my lord. Piercing. Siddhartha and piercing.
yes. No, he's having one matter. You are. Oh,
This is not
acha.
J. This is JCRL.
No. Acha, just a minute.
There are 2 matter connected matters. CRL.
Okay. It's all right. But since he has filed a regular appeal, that is CRLA number 324 of 2028, you have filed for all the appellants.
I have a Riya Munda, matter.
Huh?
Riya Munda, Vijay Munda, and Raya Munda.
No, there are
3 appellants.
देखिए এটা 3 ଜଣ ପାଇଁ ଫାଇଲ କରିଛନ୍ତି so Mr. Naik, since regular appeal has been filed, so JCRL is to be disposed of, but you are ready for you?
No, my lord.
Then
I today I received paper book, my lord.
who told you not to receive it earlier? It's a 2008 matter and is listed as item number 1, and the other counsel is ready, and you are filing a regular appeal not getting ready. Why will it grant you time?
Only
You
one
withdraw the criminal appeal, you will argue
week.
the.
Only 1 week, my lord. Only 1 week.
No question of
Piercing will appear when counsel.
whosoever appears, that's immaterial for me. This 2008 matter, it is listed as item number 1. It cannot be adjourned.
Only 1 week time I given, my lord.
Sorry. You have got the paper book.
I applied, my lord. Today I received, my lord. I have already applied, my lord.
पाई लेनी ना नहीं
पाई आज ही दे दिवस में
तब पेपर बुक दिया हैंड ओवर करो तुम एक्स्ट्रा पे 8 कोट हैंड ओवर करो देखो JCRL number 51 of 2008, since all the 3 appellants have filed criminal appeal number 324 of 2008, this jail criminal appeal is disposed of. The Lieutenant Counsel for the appellant submitted that he is yet to receive the copy of the paper book. The matter may be adjourned to next week. Let a copy of the paper book be supplied to him in court today. Matter be listed as item number 1 in the hearing list on next year. Huh? आज कौन गुरुवार आज बुधवार ना आज 1 तारीख 1 तारीख तो 8 तारीख आसो ओ CRL अच्छा ओके आम JCRL गोटे दिन रखीचु एटा नहीं तुम से ये नहीं आसो से गुरुवार ये बुधवार दिन नहीं आसो 8th November 2023 है ना so you receive the paper book and get ready.
My lord, much obliged.
Newton. So, Mr. Pradhan, they have come, Mr. Kanun go. Call your witness. The arrangement is okay? Okay.
2022,
Hmm.
or 6/10/2023, a reference has been made ଯେ ଯୋଉ ଗୁଡାକ ଆମେ କହିଥିଲୁ ସେଦିନ ଦବୁ ବୋଲିକି certified copy, we are submitting certified copies of
Land
those
Council
orders.
will provide the certified copy of the judgment of so and so. And the Land Council so and so with the memo mark to mark.
ଆଉ ଗୋଟେ ଡାଉନଲୋଡେଡ କପି ଦାଖଲ କରିଛୁ କାହିଁକି ନା certified କପିଟା ପାଇନୁ ସୁପ୍ରିମ କୋର୍ଟ, ସେଥିପାଇଁ ଗୋଟେ IAB ଦେଇଛୁ।
Respondent opposed to this and further submitted, he would supply the certified copy of the documents relating to the said case. Criminal appeal as well as okay. So the certified copy is
I feel
all right.
recollection.
Mr. Kanungo,
Yes, ma'am.
they जो केस टा आपनकर कन्विक्शन पई देइथिले
Aye.
से जो अपील ले स्टे हेइथिला
Aye.
so
These
say
are all
document
documents. They may be marked with objection. Closure, ma'am.
RW1
also
to
kichi
RW4 is complete.
just a minute. Mentioned in RW1 to respond to the evidence of our so and so is scheduled to commence today after completion of so and so examined in this behalf according to my response. So, but the order that is mentioned, I have to mention specifically because you on that day submitted that you want to examine two witnesses, right? So now you do not want to examine that.
Shakil Khan.
The last order ta ke beith lagi.
ସେଟା ହେଇଥିଲା ଅଛି ଲିଷ୍ଟରେ ରେଫରେନ୍ସ ଅଛି।
List ଅଛି ଆଜ୍ଞା। ସେଟା କେବେ ଅର୍ଡର କଲେ?
हाँ रे एटा लिखि दियंतु it should be registered and allowed hala and that through the period is 15 days hala to file the certified copy of so and so jaha lekha learn counsel for the additional documents guडा जो डॉट मार्क करचंदी सी जहा कहिबे से नंबर गुडा तांकर जो जाई जाही थिबो ता परठु नंबर एग्जिबिट सो एंड सो मार्क हे जो हला सीरियली करी मार्क कर दे then
with objection
with objection then he files a memo today in court wherein it is mentioned that after the evidence of RW5 namely Sophia Firdos, the respondent wants to close the evidence from their side, wants to close the evidence from his side. Memo is accepted. Mr. Vidyadhar Mr. Land Counsel, Land Senior Advocate submits that the respondent doesn't want to examine Mr. Shakil Khan, the election agent. Okay, close kar do. Okay, sir.
Witness.
Please take both.
I swear that the evidence which I shall give in this case shall be true, that I will conceal nothing and that no part of my evidence shall be false. So
Please
help
take,
me God.
please take your address गुरिया ठीक लिखा है जी. No, no, आप ऊपर उठेले आपण प्रथम नियम एटा RW5 ठीक अछि तो for the 5 टाको क्लोज करंतु माने लगे दियंतु ता संगे. For the respondent taken on 1st November 23, my name is Sophia Fidus. I am wife of Sheikh so. My age is 32 years. My home is at Shaidani Bagicha, Post Tulasipur, PS Lalbagh, Swanso Katak. I reside in present at Swanso. I'm an ଏଗୁଡାକ ସବୁଗୁଡାକ କାଇଁ लिखे what is your profession?
Sir, I'm an entrepreneur doing real estate business.
Business लिखो and business lady को दो.
E हिजोगा.
हाँ E हाँ and business lady को दो. Lady a lady one. You so you
Also-
just lead this
Yeah.
that is paragraph number.
मैंने also I represent sir जो builder association CREDAI as a president CREDAI Bhubaneswar.
That you have already mentioned, so no need.
Not mentioned.
Huh?
And as well as
just
recently.
So the paragraph, it is closed in paragraph number. Just a minute. Who page is paragraph? 16. So it has 16 now. I have filed my evidence affidavit. It has been scribed as for my. Just.
Evidence affidavit.
आज्ञा.
ଆପଣଙ୍କ କହିବା ମୁତାବକ ତିଆରି କରାଯାଇଛି.
Yes.
ଆପଣଙ୍କୁ ପଢି ବୁଝି ଏଥିରେ ଆପଣ affidavit କରିଛନ୍ତି.
आज्ञा.
Signature ତାଙ୍କରି.
ଏବଂ ଏ ସବୁ signature ଯେତେ ପେଜରେ ଅଛି 1 ରୁ 16 ଯାଏଁ ପେଜ ଆପଣଙ୍କର ଅଛି.
आज्ञा.
Okay. I filed my evidence. It has been scribed as per my direction. I have shown and signed the same after the contents so and so. This is the said affidavit marked as FD. And it is 16 pages. These are my signature appearing on every page so and so. Set FD/1 to FD/16. FD. Okay. I'll count pachariya tha pachari.
document guda exhibit.
Document guda.
Copy ଟା ନେବେ?
affidavit ର copy ଟିକେ ନବାକୁ ଚାହିଁବେ?
ପରେ
Sure.
ଦିଆ
What a pen paper.
One minute. Documents. Additionally.
pen paper में पकड़ ले. जी. पेंसिल बता.
It cross examination of RW5 होगा. Whether it will be a separate paragraph or sub-paragraph? Separate 17 करूँ. Yes.
এটা ଦେଖନ୍ତୁ କ୍ରିମିନାଲ ଅପିଲ ନମ୍ବର 880/2022 ର ସାର୍ଟିଫାଇଡ କପି ଯୋଉଥିରେ କି ଅନରେବୁଲ କୋର୍ଟ ଯୋଉ TR କେସ୍ ନମ୍ବର 1/2009 ରେ ଆପଣଙ୍କର ବାପା ମହମ୍ମଦ ମକିନ ଯୋଉ କନଭିକ୍ସନ ହେଇଥିଲା ତାକୁ ଷ୍ଟେ କରିଛନ୍ତି.
Paragraph 17 ne se order mention ଅଛି.
जी
pass on କରିଦିଅନ୍ତୁ। I am producing the certified copy of the order dated 19/10/2022, 19/10/2022, passed in IA number 1657 of 2022, arising out of CRLA number 880 of 2022, which was filed by the respondent, who is my father, before this court, challenging the judgment and order dated 29 September 2022, passed by the learned special judge Vigilance, Bhubaneswar, in TR case number 1 of 2009. Stop. This honorable court, in the order dated 19/10/2022, has allowed the prayer made in the interim application and stayed the impugned judgment of conviction passed by the Learned Trial Court. Stop. The certified copy of the order dated 19/10/2022 is marked as FE. All right, stop.
That is 17 seats.
Exhibit FE. You want it to be
We just
what?
said that it's with objection being irrelevant.
17 seat, marked with objection on the ground that this document is irrelevant. Bracket ends.
এটা দেখন্তু ডাউନଲୋଡେଡ୍ କପି ଅନରେବୁଲ ସୁପ୍ରିମ କୋର୍ଟ ଅଫ ଇଣ୍ଡିଆଙ୍କର ଯୋଉଥିରେ କି ଷ୍ଟେଟ ଅଫ ଓଡିଶା ଭିଜିଲାନ୍ସ এই অনরেবল হাইকোর্টଙ୍କ ଅର୍ଡରକୁ ଚ୍ୟାଲେଞ୍ଜ କରି ଯାଇଥିଲେ ସୁପ୍ରିମ କୋର୍ଟ ସେଟା ସେ ଡିସ୍ପୋଜ ଅଫ କରିଛନ୍ତି dismiss
जी
କରିଛନ୍ତି।
यस माय लॉर्ड
Pass on. I am also producing separate darkar nahi, can't say related to that. I am also producing the downloaded copy of the order dated 22/9/2023, passed by the Honorable Supreme Court of India in special leave petition bracket criminal diary number bracket S bracket dot tapar dot diyantu S par dot 3 S no S bracket bhitar rakhantu out bracket dot number is 35931/2023. Also producing a downloaded copy of the order, which was filed by the state of Odisha bracket vigilance challenging the order dated 19/10/2022 passed by this court marked as Exhibit FE, and the Honorable Supreme Court has been pleased to taking so no reason Russia didn't interfere with the order and accordingly disposed of the SLP with certain observation. Stop. The downloaded copy is marked as downloaded copy date dated 22/9/20. The downloaded copy of the order dated simply say passed by the can is marked as exhibit if double F. Yes. It will say you copy objection again. Say irrelevant.
Being irrelevant.
Say you mark with objection. 2 seats lag diyo to. Yeah.
ଗୋଟେ ରିଟ୍ ପିଟିସନ PIL ଫାଇଲ କରିଥିଲେ ଡକ୍ଟର ରବିରଞ୍ଜନ ସାହୁ, ଫିରୋଜ ଅହମଦ and ସଙ୍ଗୀତା ଦାସ against Election Commission of India, State Election Commission and Mr. Mohammed Mukim and the Director of Vigilance to dispose of the said case.
Who case?
Say criminal appeal 880/2022 जोटा जोतरे अपन ये पाइले
एटा पूरा डायरेक्शन हला ऑनरेबल सुप्रीम कोर्ट करो 20
हाई कोर्ट रे करते
अच्छा
आ गुटे केस करथिले
ओ माने ए ऑर्डर हवा पूर्व ना कोन केबे सेरा डिस्पोज ऑफ होई
डिस्पोज ऑफ 18/8 रे पांच 2/8 रे ऑर्डर
ऑलराइट
दुईटा ऑर्डर में रोड दी दोची ताको बाई बार
अच्छा नहीं सी व्हाट ही सेज दैट ए ऑर्डर टाकू ता पूर्व को नै जीवागी सीक्वेंस मेंटेन करिया पे ना दरकार नै ठीक अछि चलियो हां यस पचान प्रश्न पचान
এবং 2 तारिख दिन ऑनरेबल हाई कोर्ट ए ऑर्डर पास करथिले डिवीजन बेंच ऑफ दिस ऑनरेबल कोर्ट 880 रो 880/2022 रो स्टेटस मागिथिले एफिडेविट करबा पे गवर्नमेंट एडवोकेट को
जी
एवं 18/8/2022 रे नेक्स्ट ऑर्डर ऑनरेबल चीफ जस्टिस को डिवीजन बेंच से केस को डिस्पोज ऑफ कर दिथिले
only prayer was to dispose of that criminal appeal.
That is the only prayer.
In the public interest litigation. That was all right. I'm also producing the certified copy of the order dated 2/8/2023. Is it a same case?
Same case.
And
Order dated 18.
And 18/8/2023, 2/8/23 and 18/8/2023 passed by this court in WPC number 240 52 नहीं तो अच्छा अच्छा हाँ ठीक है WP ब्रैकेट लिखंतु C तापर लिखंतु आउट ब्रैकेट रे PIL all capital number 24052 of 2023 which was filed by Dr. Rabinanjan Sahu, comma Sahu SAHOO, comma Firoz ठीक है छाड़ीगिन Ahmad AHEMAD Khan and Sangeeta Das GEE Sangeeta Das for expediting the hearing of criminal appeal number 880 of 2022 which was filed by my father Mohammad Mukim bracket respondent and the case was disposed of on 18/8/2023. Stop. The certified copy of the two orders, that is 2/8/2023 and 18/8/2023, are marked as FG and FG by 1 respectively. Exhibit FG हाँ ठीक है गोटे केस तो FG by 1
Again with objection.
हाँ ऐसे कॉपी करेंगे टोटल सीट्स लिख दियंतु 7 हाँ से जो येटा हाँ 3 seats आउ सेटा होची 4 seats है ना हाँ आउट 2 seats रा काटी दियंतु marked with objection on the ground that these documents are irrelevant. Okay. Out paragraph. That is paragraph number 18. Yes.
Publication honorable court order क्रमे डिस्ट्रिक्ट इलेक्शन ऑफिसर कटक कोर्ट दाखल करिथिले एथिरे जे इलेक्शन पिटिशनर देवाशीष सामंतराय तांकर क्रिमिनल एंटीसीडेंट्स काढिछन ए तीनटा देखो आपण तरफर एग्जिबिट कर
Yes, my lord.
Yeah, how is this relevant? Because it's not in pleadings, not
Objection
in
करी
issue.
मार्क कर दउची सब केड़ा I am also producing
डिस्ट्रिक्ट इलेक्शन ऑफिसर
एगुड़ा अच्छा अच्छा एगुड़ा मार्क ही जाइए अच्छा
The document was produced by the election officer.
इसे
Returning officer was there. There is no issue and there is no any of pleading has been made with respect to these documents.
Let us mark it with objection. Look on the no, I'm also not producing. These are the newspaper publications made in Matrubhasha, inverted comma with the on dated 16/4/2019, 17/4/2019 and 18/4/2019 relating to the declaration about the criminal cases by the election petitioner, criminal cases pending against the election petitioner Devasi Samantray. Stop. By the election petitioner. Relating to also pending public. Say it last two legend. Published by the election petitioner. Stop. The aforesaid newspaper publications are marked as ये बाई कर दूंगा FH by 1 comma कर दूंगा FH by 1 and FH by and कर दूंगा and FH by 2 respectively कर दूंगा so total हल्ला FH then FH by 1 then FH by 2 मतलब कि ये objection marked with objection these documents are irrelevant and also irrelevant and also on the ground that there is no pleading in that respect. Yeah.
Okay.
এটা দরকার Mr. Kanungu wants to come? But
in your affidavit, you have stated that whatever you have stated in this affidavit are based upon your knowledge and based upon documents. What are those documents on the basis of which this affidavit has been prepared?
ଆମେ ଆମର ଆଡଭୋକେଟ ବାପାଙ୍କର ଆଡଭୋକେଟଙ୍କର ଚେମ୍ବରରେ
ଆପଣଙ୍କ knowledge ରେ କଣ document basis ରେ ତିଆରି ହେଲା? ମୁଁ advocate ଙ୍କ କଥା ପଚାର।
ମୋ knowledge ରେ ଯୋଉ form 2 ବି ଥିଲା ସେଟା ମୁଁ ଦେଖିଛି ପ୍ଲସ୍ ମୋର representation ବି ଦେଖିଛି।
This affidavit has been prepared on the basis of form 2B and your authorization letter.
There were other documents also jota mention ହେଇଛି।
What are those documents?
I can see and tell. ଆପଣ numbers ଗୁଡାକ
What
ମତେ
are
ମନେ
those
ରହିବ
numbers?
ନାହିଁ.
Whether you can tell or not,
Mr.
you
Khan.
remember or not.
Voice speaker.
No, actually, my lord, my voice is I am
Yeah,
not a
It's a high pitched
voice
Maybe
problem.
she might be feeling nervous.
That I can understand, my
It's
lord.
okay, sir.
It's not my voice is high. Whether
Yes.
you know about those documents or not.
Yes, I'm aware about all the
What are
documents.
those documents?
ଯେମିତି ମୁଁ ଆପଣଙ୍କୁ form 2 ବି କହିଛି, authorization ଦେଖିଛି ମୁଁ, plus ତିନିଟା ଯାକ ଆମେ
What is the
ଯୋଉ ଦେଲୁ,
authorization? Authorization?
Authorization regarding her,
I was
she
the-
was appointed to go attend the scrutiny.
Oh, achha. Authorization for attending the scrutiny.
Scrutiny.
yes, on behalf of the
Okay.
candidate,
No,
along-
whatever documents you just remember, you tell. There is no.
along with the the downloaded version of Supreme Court and the 2 orders that we have given, as well as newspaper publications that we have given.
Today's documents mark exhibits.
Yes.
Okay. In paragraph 15 of my evidence and affidavit filed today before this court, I have mentioned that the facts stated in my evidence affidavit, inter alia, based upon documents, and those documents are Form 2B, authorization letter. Who has given you the authorization letter?
Respondent has given to attend scrutiny.
Authorization letter issued by my father, bracket respondent, to attend
The scrutiny of
the
nomination
scrutiny
papers.
of nomination, newspaper clippings, and certified copy of the orders and downloaded copy of the order which are filed today, which are filed today by me, which are already marked as which are already marked as exhibits today. Yes.
ଆପଣ ତ ସ୍କୁଟିନିରେ ଯାଇଥିଲେ,
ଆଜ୍ଞା,
ଆପଣ କହିପାରିବେ କେତେଟା କ୍ୟାଣ୍ଡିଡେଟ୍ ନମିନେସନ ଫାଇଲ କରିଥିଲେ ଏବଂ ଟୋଟାଲ କେତେଟା ସେଟ୍ ନମିନେସନ ପେପର ଫାଇଲ ହେଇଥିଲା ରିଟର୍ନିଂ ଅଫିସର?
ଯୋଉ ଦିନ ମୁଁ ଯାଇଥିଲି ସ୍କ୍ରୁଟିନି ପାଇଁ 11 candidates total ଫାଇଲ କରିଥିଲେ, and ଗୋଟେ candidate ର 4ଟା set ରୁହେ.
କେତେଟା ମୁଁ ଗୋଟେ କେତେଟା କ୍ୟାଣ୍ଡିଡେଟ୍ ଟୋଟାଲ ଫାଇଲ କରିଥିଲେ
ଜି।
nomination?
11ଟା ପରା କହିଲେ 11ଟା।
11ଟା।
and କେତେ ସେଟ୍ ଟୋଟାଲ ନମିନେସନ ଆରଙ୍କ ପାଖରେ ଫାଇଲ ହେଇଥିଲା? ଯୋଉ
ଜଣେ
11ଟା କ୍ୟାଣ୍ଡିଡେଟଙ୍କର ଟୋଟାଲ କେତେ ସେଟ୍
ବୁଝିଗଲି।
ନମିନେସନ ଥିଲା?
ଖାଲି ଜଣେ କ୍ୟାଣ୍ଡିଡେଟ୍ ଗୋଟିଏ ସେଟ୍ ଦେଇଥିଲେ, ସେ ଆଉ ତିନିଟା ଦେଇନଥିଲେ, ତ 41 ପାଖାପାଖି around, I think.
Around 41. All right. 11 candidates filed nomination paper to contest the election for 90 Baravati se jota likhi Assembly constituency of Swans, Baravati Cuttack Assembly constituency.
Election from
90 contest the election from उन्हें off तक काट दूं
ऊपर लाइन
हाँ ठीक from 90 Baravati Swans and according to me about 41 sets of nomination papers were filed by the candidates in total. Stop.
ଆପଣ ଏ କେସ୍ ରେ ଆପଣଙ୍କ ବାପା ଯୋଉ ଜବାବ ଦାଖଲ କରିଛନ୍ତି ତାକୁ ପଢିଛନ୍ତି?
ମୁଁ ଦେଖିନି।
I have not gone through the written statement filed by
ରେସ୍ପଣ୍ଡେଣ୍ଟ।
the respondent.
ତାହେଲେ ଆପଣ ଇଲେକ୍ସନ ପିଟିସନ ବି ରେ ବି କଣ ଅଭିଯୋଗ ହେଇଛି ସେ ବିଷୟରେ ବି ଆପଣ ଜାଣିନାହାନ୍ତି?
ମୁଁ ମାନେ ପଢିନି କିନ୍ତୁ ଯାହା ଶୁଣିଛୁ ଆମେ ମିଡିଆରୁ
ଶୁଣିଛନ୍ତି,
ସମସ୍ତଙ୍କଠୁ
ନିଜେ ପଢିନାହାନ୍ତି?
କି ଫର୍ମ 2B objection ହେଇଛି।
I have not gone through the election petition, but I am aware to some extent about the pleadings made in the election petition.
ଆପଣ ଦେଖନ୍ତୁ ଆପଣଙ୍କ ଆଫିଡେଭିଟ ର ପେଜ 16
Affidavit.
ଜି
ଏ ଯୋଉ ଲେଖିଲେ ଆପଣ appropriate submission shall be made in respect before this honorable court by the advocate. What do you mean by appropriate submissions? Page 16 of top my lords.
पूर्व सेंटेंस टा क्वेश्चन पैराग्राफ
से जो ऑर्डर गुरा
and produced by this also newspapers and declaration on the same matter they gives well appropriate submission shall be made in that respect before this one so by my the advocates at the time.
What do you mean by appropriate submissions?
सबमिशन माने सर हम फादर को एडवोकेट से डिटेल्स रे कहबे।
ଆପଣ ଜାଣିନାହାନ୍ତି ସେ ବିଷୟରେ କଣ କହି ଲେଖା ଯୋଉ ପାରାଗ୍ରାଫ ରେ ଯୋଉ ଲେଖିଲେ ସେ ବିଷୟରେ ଆପଣ କିଛି ଜାଣିନାହାନ୍ତି?
ମୁଁ ଯେତିକି ଲେଖିଲି ବ୍ରିଫଲି ଜାଣିଛି ବଟ୍ ଯେହେତୁ ମୁଁ ଲାଷ୍ଟ ୱିଟନେସ୍ ତ ଆମେ ଏଥିରେ ସବୁ ଏକ୍ସିବିଟ୍ କରିଦେଇଛୁ एंड एडवोकेट विल फर्दर आर्ग्यू।
in detail ଆପଣଙ୍କର advocates କହି ପାରିବେ ଏଇ ସେନ୍ସ ଲେକ୍ଚର ନା କଣ जो डॉक्यूमेंट गुड़ाक आपण से पैराग्राफ 13 रे उल्लेख करछंती
जी सर।
सेडा तो ऑलरेडी मार्क हेई गला
यस सर।
बट ए जोटा से प्रश्न तांकर होची जे आ उटा लिखिछंती जे एप्रोप्रिएट सबमिशन शैल बी मेड ये एप्रोप्रिएट सबमिशन माने कोन
विल बी मेड इन रिस्पेक्ट ऑफ द जति कि हमें डॉक्यूमेंट मार्क करलु तारो अप्रोप्रिएट सबमिशंस विल बी मेड बाय द एडवोकेट।
क्वेश्चन क्यू कर दियंतु व्हाट डज इट मीन बाय the words inverted comma भितर appropriate submission as mentioned submissions करंतु as mentioned in the sub paragraph of paragraph number 13 of your evidence on affidavit question mark answer my the advocates of my father
respondent
the advocates of the respondent yes what do you say
I have just attached the documents and the advocate of the respondent will make further submissions
about the relevancy of those documents से
Will-
तार कौन पाई फाइल कले से
yes sir about
the
the relevance।
advocates of the respondent shall make submission about the relevancy of such documents as mentioned in paragraph number 13. Yes.
You don't have any personal knowledge about those documents.
I know that जहाँ केस तीनटा जाको फाइल ହେଇଥିଲା but in depth let the advocate make submission।
Next one subpara kariba not question I have and I am aware about the contents of the orders kar diyantu which were exhibited today on my behalf. So also the newspaper clippings
Publications.
as a newspaper publications would a word would a clippings publications newspaper publication, but in detail I cannot say about the same, and the advocates of the respondent can make submission in extenso on those documents. Extenso, not extensor, so extenso on those documents. Stop.
ଆପଣ ଏଇ ଏଭିଡେନ୍ସ ଏଫିଡେଭିଟ ଯୋଉ ସବୁ କଥା ଲେଖିଛନ୍ତି ତାକୁ କେବଳ ଏଇ ଯୋଉ କୋର୍ଟ ଅର୍ଡର ଆଉ ନ୍ୟୁଜ ପେପର କ୍ଲିପିଂ ଛାଡିକି ପାରାଗ୍ରାଫ 13 ଏବଂ 12 and 13 ଯୋଉ କଥା ପାରା 12 ଆଉ 13 ରେ ଯୋଉ ଡକୁମେଣ୍ଟ କଥା ଛାଡିକି ଆପଣ ବାକି ଯୋଉ ପାରାଗ୍ରାଫ 1 ରୁ 11 ଏବଂ ପାରାଗ୍ରାଫ 14 15 ଯୋଉ ଲେଖିଛନ୍ତି ତାକୁ ସବଷ୍ଟାନ୍ସିଏଟ କରିବାକୁ କଣ ଡକୁମେଣ୍ଟ ଆପଣ ଦାଖଲ କରିଛନ୍ତି କୋର୍ଟରେ?
କୋଉ paragraph କହୁଛନ୍ତି 1 to
para 1 to 11 my lords
ଆଉ
and 14 and 15
14 and 15 13 ଟା ତ କହିଦେଲେ ସେ
12 13 ତ ଡକୁମେଣ୍ଟ ଅଛି।
या भितरु already advocates have furnished the authorization letter of authorization letter on behalf of the respondent to be present during the scrutiny of nomination papers. Again,
You have not seen any other documents.
I have because form 2B ମୁଁ ଆଗରୁ କହି ଦେଇଛି ଆପଣଙ୍କୁ।
Form 2B ଆପଣ ଆପଣଙ୍କ ବାପାଙ୍କ କେବଳ ଦେଖିଛନ୍ତି।
ସେଇଟା ଯେତିକି ଆପଣ କହିଛନ୍ତି ସେଟା ତ ଲେଖା ହେଇଗଲା।
Form 2B
ବାକି just a minute Mr. ଏଇ ଡକୁମେଣ୍ଟ ଯୋଉଗୁଡାକ ଛଡା ଆଉ ବାକି ଯୋଉ ଆଭରମେଣ୍ଟସ ଆପଣ ଡିଫରେଣ୍ଟ ପାରାଗ୍ରାଫ୍ସ ରେ ନେଇଛନ୍ତି ତାର ରିଲେଟେଡ ଡକୁମେଣ୍ଟ କୁ ଆପଣ ନିଜେ ଭେରିଫାଏ କରିଛନ୍ତି କି ବାସ୍ ତାକୁ ଦାଖଲ କଲେ କି ଆଜି?
ଯେତିକି sir context ଅଛି from 1 to 11 my lord ସବୁ context mainly form 2B କୁ ନେଇକି ଅଛି but already court ରେ present ଅଛି।
All right, whatever I have mentioned in paragraph number 1 to 11 so also in paragraphs number 14 and 15 are based on documents which are already available in the court record. Stop. In the court records of this election petition proceeding, of this election petition proceeding. Election petition proceeding. ठीक है।
ଆପଣ ଆପଣଙ୍କ ବାପାଙ୍କର ଫର୍ମ 2B ଛାଡିକି ଅଲଗା କାହାର ଫର୍ମ 2B ଦେଖିଛନ୍ତି?
ଯେହେତୁ ସେ ସ୍କ୍ରୁଟିନି ଦିନ ଆମେ ପ୍ରେଜେଣ୍ଟ ଥିଲୁ as authorized representative ମୁଁ ଥିଲି plus representatives from the petitioner side were also present. So sedino returning officer as per the representation of people act se samastanku nomination papers dothile check kariba pai se 11 candidates ro nomination paper pachaku pathautile to ame gote glimpse dekhichu samastanko nomination paper
ସମସ୍ତଙ୍କ nomination ଦେଖିଛନ୍ତି।
I have during scrutiny of the nomination paper I got the opportunity to go through the nomination papers of all the 11 candidates. Yes.
ଆପଣ କହିପାରିବେ କି ଆପଣଙ୍କ ଏଭିଡେନ୍ସ ଏଫିଡେଭିଟରେ ଯୋଉ କଥା ଆପଣ ଲେଖିଛନ୍ତି ସେଇଟା ଆପଣଙ୍କ ବାପାଙ୍କ ଜବାବରେ ଲେଖା ହେଇଛି କି ନାହିଁ?
ସେଇଟା ମୁଁ କହିପାରିବିନି।
I cannot say whether the averments taken, the statements made in different paragraphs of my evidence on affidavit are available in the written statement of the respondent or not.
ଦେଖନ୍ତୁ ଆପଣ ये इलेक्शन पिटिशन पढ़ी नांती किंबा ଆପଣଙ୍କ ବାପା ଯୋଉ ଜବାବ ଦାଖଲ କରିଛନ୍ତି ତାକୁ ବି ପଢି ନାହାନ୍ତି, and whatever you have stated in your evidence affidavit are all irrelevant and false.
It is not a fact that I
No,
have
my
not.
lord.
All right, I'm writing that. It's not a fact that I have not gone through either the election petition or the written statement filed by the respondent, and I have no knowledge about this election petition proceeding, and I have stated falsehood in the
irrelevant and false.
I have stated irrelevant things and falsehood in my evidence and affidavit.
So also, except paragraph 1230, you have not filed any document to validate your statement made in your evidence affidavit.
I have filed the authorization, and because all the things that I've written is based on the instances, so already in the RO office, whoever was nominated on behalf of candidates were present there, so they know whatever has happened there, and just that thing only I've mentioned in my affidavit.
It's not a fact that the statements made by me in the evidence and affidavit are based on no documents, and just to help my father bracket respondent comma I have come up with this evidence and affidavit. To quote karantu. On 5/4/2019 ଆପଣ କୋଉ ସମୟରୁ କୋଉ ସମୟ ପର୍ଯ୍ୟନ୍ତ रिटर्निंग ऑफिसर ऑफिस रे प्रेजेंट थिले?
सर एग्जैक्ट टाइम तो मने नहीं कि माय लॉर्ड, किंतु जेतेबेले स्टार्ट हैला वी रीच्ड अबाउट 15-20 मिनट्स अर्लियर,
No, what is the time? 15-20 minutes earlier means
11 AM time thila sir. My lord, 11 AM ପୂର୍ବରୁ ଆମେ ପହଞ୍ଚି ଯାଇଥିଲୁ and we were there till the last.
till the last ମାନେ କୋଉ ସମୟ ପର୍ଯ୍ୟନ୍ତ?
My lord, I think 3 ଘଣ୍ଟା ତ ଲାଗିଥିଲା.
So you were there present prior to 10 to 15 minutes prior to 11 o'clock on 5/4.
Yes, my lord.
And you left that office around?
My lord, around afternoon.
Time कुहतु data
I'm not able to exactly recollect.
afternoon ମାନେ afternoon तो पूरा पड़े आसीबो 12टा
I only remember that I was there till the last.
last ମାନେ
ମାନେ final nomination
केबे
papers.
time टा केते कोन अंदाज करी कोन you are there, we are not there. So you are supposed to tell. The question is that केबे केते बळे approximately आपण छाडिले 2टा 3टा 4टा 5टा जहा कहबे लिखा हो.
Approximately 3टा बेले.
I reached the office of the returning officer bracket re PW3 on 5/4/2019 at about 10:45 a.m. and I left the office around 2 p.m. na pehle around 2 p.m. ଆପଣ ସେଦିନ ସେଠି ପ୍ରେଜେନ୍ସ ଥିଲେ ଏ ବିଷୟରେ ଡକୁମେଣ୍ଟାରୀ ପ୍ରୁଫ ହଉଛି କେବଳ ସେଇ ଆପଣଙ୍କର ବାପାଙ୍କର ଅଥରାଇଜେସନ ଲେଟର ଯୋଉଟା କି ଆପଣ ପ୍ରୋଡ୍ୟୁସ କରିଥିଲେ ରିଟର୍ନିଂ ଅଫିସର.
Yes, my lord.
The only proof available regarding my presence on the date of scrutiny of nomination paper is the authorization letter of my of the respondent in my favor to attend the scrutiny, which has it a mark which has already been marked as exhibit so and so. ଆପଣଙ୍କ ତରଫରୁ ଆପଣ ଯେତେବେଳେ ସ୍କ୍ରୁଟିନି କଲେ କୌଣସି କ୍ୟାଣ୍ଡିଡେଟ ବିଷୟରେ ଆପଣ କିଛି ଆପତ୍ତି କରିଥିଲେ ଯେ କ୍ୟାଣ୍ଡିଡେଟ ଆମକୁ ସପ୍ରେସ କରିଛି ଏଟା ଇଏ କରିଛି ଆପଣଙ୍କ ତରଫରୁ କିଛି ଅବଜେକ୍ସନ ହେଇଥିଲା?
My lord, ଗୋଟିଏ କ୍ୟାଣ୍ଡିଡେଟ ଲାଷ୍ଟ ରେ
ମୁଁ ଆପଣଙ୍କ ଆପଣ ପର୍ସନାଲି ଯୋଉ କହୁଛନ୍ତି 11ଟା ନୋମିନେସନ ପେପର 11ଟା କ୍ୟାଣ୍ଡିଡେଟ କର 41ଟା ନୋମିନେସନ ପେପର ଭେରିଫାଏ କଲେ ଭେରିଫାଏ କଲା ପରେ ଆପଣ ନିଜ ତରଫରୁ କୌଣସି କ୍ୟାଣ୍ଡିଡେଟ ବିଷୟରେ ଆଉ ଯୋଉ ବାକି 10 ଜଣ ରହିଲେ ତାଙ୍କ ବିଷୟରେ ତାଙ୍କର affidavit ରେ ହଉ କି ସେ ଇଏରେ କିଛି ଭୁଲ ଚୁକ୍ ଅଛି ବୋଲି ଏମିତି କିଛି ଅବଜେକ୍ସନ କରିଥିଲେ କି ଆପଣ ନିଜେ? Don't look at here and there.
My lord, ମୁଁ objection କରି ନଥିଲି.
I have not raised any objection relating to the nomination paper of any of the candidates verified by me on that day. Stop. ଆପଣଙ୍କର ବାପାଙ୍କର ନୋମିନେସନ ପେପର ଅର୍ଥାତ ମିଷ୍ଟର ମୁକିମଙ୍କର ନୋମିନେସନ ପେପର ସେ ଯୋଉ 10 ଜଣ ଯୋଉ ଅନ୍ୟ କ୍ୟାଣ୍ଡିଡେଟ ବା ତାଙ୍କର ଯୋଉମାନେ ଏଜେଣ୍ଟସ୍ ଥିଲେ ବା ତାଙ୍କର ଯୋଉମାନେ ସେମାନେ କିଛି ଅବଜେକ୍ସନ କରିଥିଲେ?
My lord, ବାପାଙ୍କର ସିରିୟଲ ନମ୍ବର 2345 ଥିଲା ତ ଇନିशियली ପଡି ଯାଇଥିଲା. So RO as per ସେ ସମସ୍ତଙ୍କୁ ପଛରେ ପଠେଇଥିଲେ and as far as I remember it election petitioner tarafru bhi advocates were sitting in the front. I can recall Asim Amitav sir.
ପ୍ରଶ୍ନ ହଉଛି ଯେ ଆପଣ ତ ଅବଜେକ୍ସନ କଲେନି ସେମିତି ଆପଣଙ୍କର ବାପାଙ୍କର ଯୋଉ ନୋମିନେସନ ପେପର ଫାଇଲ ହେଇଥିଲା ବା ତା ସାଙ୍ଗରେ ଯୋଉ ଡକୁମେଣ୍ଟ ସବୁ ଫାଇଲ ହେଇଥିଲା ସେ ବିଷୟରେ ଅନ୍ୟ କେହି ଅବଜେକ୍ସନ କରିଥିଲେ କି?
କେହି କରିନଥିଲେ.
No one present at the time of scrutiny raised any objection relating to the nomination papers filed by the respondent. All right, that's all. एटाও କିଛି करेक्शन एक करियो ना से साइन कर दीजिए ठीक अछि ऑलराइट प्रिंट आउट कर दियंतु हां me about the next
Evidence disclosed the defendant has the right to start because they are saying we are not entitled to any relief.
no
No. They have closed. So they have to begin.
Now the case is to be posted for argument.
Madam.
So the beginning is to be made by you. How he will please show the provision.
Order 18 Rule 1.
Order 18 Rule 1.
Just civil procedure code authority. Yes.
Well, it's Order 18 Rule 1. Right to begin. The plaintiff has the right to begin unless the defendant admits the facts alleged by the plaintiff and contends that either in point of law or on some additional facts alleged by the defendant, the plaintiff is not entitled to any part of the relief which he seeks, in which case the defendant has the right to begin. They are saying that we are not entitled to any of the reliefs that we seek, Manoj. So it is
No, that stage is already over. Now we are at an argument stage. That
yes,
is
right
to begin. If I correctly understood, this is the first section, which is there under the heading of hearing of the suit. So we have already crossed that stage. We are now at the stage of argument. There is in the CRPC, there is different stage has been. One of the stage is the argument.
Yes.
So here there is nothing like that. After this procedure thing is over, then it is straight away the one chapter comes, the judgment to be pronounced, that is in order 20. But there is no specific, is there any specific order which indicates about the argument which to begin anything, or any judgment law is there, Mr. Mishra?
Right now, I cannot say offhand, but I will supply the provision. The plaintiff is to begin.
So far as the argument
is
close କରନ୍ତି ସେ start
ଯିଏ କ୍ଲୋଜ କଲେ ସିଏ ଆର୍ଗୁମେଣ୍ଟ କରିବେ।
ଆମେ ଚିପ୍ କଲୁ ସେ କ୍ଲୋଜ ସାରିଲେ 10 ବେଳେ କ୍ଲୋଜ କଲେ ଯିଏ କ୍ଲୋଜ କରନ୍ତି ସେ ଆର୍ଗୁମେଣ୍ଟ ଷ୍ଟାର୍ଟ କରନ୍ତି that is the procedure.
No. You see, let us take an example of a criminal case. I'm telling you, criminal case, prosecution witnesses are examined, then cross-examined. It is closed, then accused statement is recorded, then defense evidence is recorded, and prosecutor cross-examines it. So after that, the next stage comes for argument. So argument is usually done by the public prosecutor because he has to prove its case.
Yes.
Okay.
Yes.
So if he says that there is no case in view of the evidence, matter ends there. So, but if he says that,
is also the same.
So first of all, normally when you are Mr. Kanungo, what I subject to what you say, that when you are pleading that for this defects, the election should be declared as null and void. So you are to, whatever evidence you have brought on record, oral evidence or documentary evidence, you should first substantiate that on the basis of this oral evidence or on the basis of this documentary evidence, my case is to be allowed, or the decree is to be passed in my favor. Then they are to, so in that way, you are to begin. So that is.
It come up tomorrow for 5 minutes. We'll satisfy
only if you say only on this point, just because, or if they begins, no, there is nothing that, suppose after you they make their submission, there is nothing that thereafter you cannot make. You can.
No, he can reply.
So there is no problem in that. But since you are objecting that no, they should begin, then Mr. Mishra says that there are citations to show that in the argument the plaintiff is supposed to begin. So
tomorrow I pray your lordship.
Mr. Mishra kali rakh 5 minute pai knowledge jodi ei guda khali egala pare apon rakhi argument
गुरुवार
खाली citation देबे आ
शुक्रवार को रख
हो ठीक अछि अपन एति खाली just relevant किए begin करिवो, but you are free after you, he can say, you can give reply. If anything he wants to say, he also can add. There is no problem in that. आपण तांकर argument रे मने करंतु किछि से point out कले, so you are free to answer to that. There is no.
मिलर सोमवार को ठीक काइंडली रखंतु काइना मिस्टर विश्वाल will not be available tomorrow and day after.
आपण आउ गडांतु नी
नाही मु गडो
ସରିଗଲାଣି ତାଙ୍କ ଆମର
ଆଜି କେତେ even I curtailed one witness.
Only on this point. I just
only on this point.
Otherwise, I would have straight put that you are to argue this. But since he's Mr. No, objection ଆସୁଛି ତ ଆପଣ ମୁଁ ସେଇଥିପାଇଁ ତ ରଖୁଛି ନା, ସେ କହୁଛନ୍ତି ଯେ ଆପଣ begin କରିବେ ବୋଲି. So once
Friday my associate will not be there.
It's on a point of law. Actually,
Sunday, Thursday and Friday.
All right, we'll take up on 6th of November 2023. Lekhon, the setup close kar debe. On consensus of both the parties, the matter is posted to 6th November 2023 for argument. Khali pardesh karjo. Ethi kardo, tapre kiye begin.
The argument date may be fixed. जदि आमर आरंभ करिया कथा आमे आरंभ
कर मु तो रखी देली argument मु खाली लिखी देली argument. This case is posted to argument. जदि सेदिनो माने हुए जे नाही आपण argument करबे, you also come ready with that.
Yes.
Because, and if it is said that no, they are to begin, they will also begin there. I am posted only to see the law point and then we'll start it. But for that, don't delay the matter.
No,
because we have माने अन्य माने सेमानकर केस को ये करी आमे एते समय देइछु जदि केस रे
the entire bar is suffering.
तेणु माने नो नो इट्स ऑल राइट माने 100 केस लिस्ट होई कि नहीं मु टेक अप करी पारुनी एट गिविंग टाइम तेणु जदि
आଜି
मु
ଆମର further prayer ହେଉଛି ଆମେ କେତେକ ଯେତେ
I would more it is my request to all of you that both of you that ଆପଣଙ୍କର ଯେତେବେଳେ you start preparing for that written note of submission ଆପଣ written note of submission को detail एते करिवा दरकार नै मनकर issue number 1
just to sketch
आपण sketch एई डॉक्यूमेंट आपण रिलाय करछंती ए विटनेस रो एई पैराग्राफ एई पेज नंबर रिलाय करछंती एती खाली ये कोन आ सेगुडा कारण एते जिंस लेखिला माने से तो 200 300 पेज हेई तणु आपण कारण गुडा इश्यू फ्रेम हेई तणु आई हैव टू टच ऑन ऑल दीज इश्यूज तणु ताको आंसर करिया पड़ियो आपण जदी गोटे इलाबोरेट वे रे सब ये रे माने देबे नॉट नेसेसरी एट ऑल आपण से आर्गुमेंट बेले मध्ये स्टिक कर जांत जे इश्यू नंबर 1 रो आपण एंड आल्सो द साइटेशंस गोटे पॉइंट रे आपण जोटा बेस्ट डिसीजन अछि ताकू दियंतु नॉट गोटे सेही पॉइंट रे रिपीटेड सॉटा जेटा अननेसेसरली टाइम यो the judgment body body chaliyo page number sei kine so please try to cooperate as you have already cooperated till now so try to finish the argument as quick as possible and on the last date of argument you also file your written note of submission and the citations if any and then we'll close and for the judgment.
I have got a humble prayer.
Yes.
So far we have been applying and your lordship have been ordering, directing the office registry to give certified copy of the exhibits. But some exhibits we have already taken, some are not yet applied for. RW1 परठारु ଆମେ ଆଉ ନେଇନୁ. That may be
माने evidence copy नेबे तो
evidence copy and exhibit copy.
ओ जो exhibits गुडा को तो आपण भी पाई नांदी
कॉपी तो हमें डेली नउछु
हां नै से तो कॉपी दिया ही होची
कॉपी आल्सो वी आर नॉट
no if you Mr. Mishra say that you will apply and if you want to apply and I am
सेटा दी ऑर्डर रे रखि दियो
if say that the order टी चेक कर देबे अपन दी जन साइड if certified copy of the deposition of the witnesses examined on behalf of the respondents are applied for along with the documents if any the same shall be supplied to the respective parties on proper application immediately by so then last to likhibe the case is posted to 6th November 2023 for argument
at 2 o'clock
at 2